He does get here. Start right now.
Hi, sorry, late introduction.
No,
okay.
it
sure looks like it's going to. I hope so. Those are my favorite. I love corn.
Even when it's just not.
I don't have to feel right. I did it in my day. I love corn. I'll just listen really well.
Jim Beard. I know you. Okay. You're fine. Oh, Kurt, you're with, okay, and Raphael's here. They live on the and I just haven't seen you.
Well,
Buy your eggs.
yeah, you should be here. Yeah, you should be here. Where's your phone?
And we've got the clicker and, yeah, one. We've got a few things.
Great setup.
No, a few housekeeping. Maybe John will just start off.
Or John.
Is there an official meeting?
Yeah, because we have a joint meeting with the plans and the ZBA and the board.
Open their meeting.
Yes, but I don't think we have a quorum. He's the board, interesting, so we'll be good, but, yeah, that's no good, so. And the on-position. Very good, and then feedback from Mike, last time, and chair of the.
I,
Two AAAs.
yes, ma'am.
Well, maybe not, wait a minute. There it goes. Oh, this is what?
Hi, Chris. Mike Stein, nice to meet you. Nice to meet you. So you'll be our new building committee, sound like?
Yes, so I'll be.
Yeah.
The process of building?
Yes, you will be here.
But he said if he's not.
Yeah, if you, when you hit the agenda item, I'll get started. You should be next.
We'll grab it if you don't have to.
We're good at that.
We are, yes, ma'am.
So, that was fun.
Hey. Hey, Raphael.
Hello, Robbie. Sorry.
Did I call it?
Yes, you did. I saw it and I thought of you. Oh my
Yeah, around here, it's usually enough.
I mean, no, I need direction to plan.
Oh, yeah, go right there, right?
Yeah, I can't do that.
You have show.
Okay. Are we ready?
I like this stuff, but, yeah.
We got that, we're back from that, like, county.
Thank you. Thank you. Good to meet you.
What's your name?
My name is Karen Scullion.
Oh, yes, okay.
Okay, is everybody all set?
I think we are.
Okay. All right, we're gonna go ahead and call the meeting to order here. Special joint meeting, workshop of the Planning Commission, Zoning Board of Appeals, and Board of Trustees. If we could all rise for a moment of reflection, followed by the pledge of allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
right, first thing we're gonna do is take roll call here. Each board will call their role individually. The planning commission will go first.
Roll call. Chairman Mike Stabb.
Here.
Commissioner Shirley Tuggle, present. Claudia Brown.
Yes.
Barbara Jones.
Present.
Calvin Vallison.
Here.
Tony Walters.
Here.
Stacy Greenwood, liaison.
Here.
Quorum present.
Zoning Board of Appeals, Chair Karen Scullion, present. Claudia Brown, liaison. Here. Jim Barron.
Here.
Terry Good. Goldie.
Here.
I'm sorry.
That's okay.
I have a quorum. I guess, okay. All right, I'm good to go.
Then Board of Trustees, Supervisor Jones here, Clerk Baraco here, Treasurer Miller. Absent. Trustee Hires, absent. Trustee Beamish, absent. Trustee Greenwood.
Here.
Trustee Dean, absent. 3 present.
No quorum.
No quorum.
All right, thank you. Next item is the approval of the September 7th, 2023 special meeting agenda. Do I have a motion?
A motion.
Second.
Okay.
Barb moved, Kevin supported. Any discussion on the agenda? All right, we go. No, we need a roll call. All right, seeing none, roll call, please.
Okay. Trustee Stacy Greenwood.
Yes.
Commissioners Barbara Jones.
Yes.
Claudia Brown.
Yes.
Kevin Vallison.
Here. Yes.
Tony Walters.
Yes.
Shirley Tuggle. Chairman Mike Stabb.
Yes.
We have 7 quorums present. Agenda approved.
All right, next item on the agenda is the approval of the July 25th, 2023 Planning Commission meeting minutes. Do I have a motion?
I'll motion. Second.
Second by. You ready for roll call?
Is there any discussion on those meeting minutes from the Planning Commission? Okay. Go ahead.
All right, Chairman Mike Stabb.
Yes.
Trustee Stacy Greenwood.
Yes.
Commissioners Barbara Jones.
Yes.
Shirley Tuggle, yes. Claudia Brown.
Yes.
Kevin Vallison.
Yes.
Tony Walters.
Yes.
Okay. Quorum. Minutes approved.
All right. Next item will be our introductions. Obviously, the Planning Commission all knows Raphael Casson from the McKenna Group. He has brought his
Extra firepower.
Extra firepower. Extra firepower
Yes.
this evening. Chris Corey, is it?
Yes, correct.
Okay. They are going to put a little presentation together for us regarding kind of, you know, the roles and responsibilities of each of the different boards and how they kind of intertwine with each other. And then I think he's going to give us a couple of examples of, you know, common things that you're going to see, and then, you know, kind of the procedure, if you will, of what to look for and what to do as far as like a variance request or, you know, like a rezone or something like that. Correct? Yeah, so gentlemen, take it away. And you guys all have a copy of the, of the PowerPoint presentation in front of you, with, you know, areas to take notes on if you want. All right. Yes, sir.
Thanks, Mike.
Yeah.
So, as Mike said, my name is Chris Corey. I'm the West Michigan manager for McKenna. And I guess I'll start with an announcement for some of you who may not have heard, and that is that Raphael has the honor of having been appointed the Director of Community Development, is that the title?
Yes.
For Clinton County. So he'll be leaving our organization, unfortunately, but hard to begrudge him a job with the word director. So unfortunately, he will not be able to take you guys through the finish line of the master plan or with the zoning ordinance, but I will be doing that, so you'll start to see me a lot more. And it's just actually pretty good timing to do this as we make this transition. And really talk to you guys about, well, actually what we want to do is take a step back, because you guys have been working really hard on the master plan. We're going to dive into the zoning ordinance soon. You've obviously had a lot sort of going on. So let's take a step back today and say, what does it mean to be on the various boards and commissions of this township? What is the master plan? What is the zoning ordinance? Why are these things important? And what is your job as elected and appointed officials of this community in safeguarding this community through these documents, right? Hopefully that way we can all get a really nice understanding of that, and that will help us move forward with these processes of updating the documents. So at this point, I'm going to turn over to Raphael to go through a few things, and then I'll talk a little more at the end.
Thank you, Chris. Hi, everybody.
Hi.
Happy, is it fall yet, technically, is it?
No.
Not yet.
Not yet.
I don't know if this is gonna last, I'm like,
A few
you know,
more
it's
days.
gonna really,
Up to 4 weeks.
everybody have a good summer.
Yeah.
Are you gonna travel less?
Yes, I will be traveling less, yeah, so, one thing I also, on a personal note, so we recently, took on, sort of a long-term foster situation, which is also, you know, precipitated me being more closer to home, and, you know, I love coming out here, don't get me wrong, but, you know, 20 minutes round, 40 minutes round trip, I mean, this thing, you know. All right, so, yeah, we got a clicker here, okay. So, some of this is gonna be review, and I think, you know, I want this to be, it's a small enough group, and we more or less all know each other. I think, you know, this is gonna be a conversation, and I'm gonna have Chris chime in. As I said to, I'm gonna embarrass Chris a little bit here, but as I said to Mike, there are probably 5 people in this world in whose presence I feel humble. This is one.
That's really nice of you.
Yeah, he wasn't figuring to say that, but it's true. It's true.
But the bar's getting pretty high.
No pressure, guys. No pressure. No pressure at all. No, you're in very good hands with this. I honestly would say that. We'll just jump right in. So, planning and zoning team. This obviously should be reviewed. We got. By the way, just show of hands. Planning commission, raise your hands.
We're all here.
Okay, awesome. Board. ZBA. Okay,
And they're-
everybody's here.
They're all.
They're all here. All right, good. All right. Excellent. So, Township Board, Planning Commission, Zoning Board of Appeals, staff, consultants, right? These are your players, right? When we're talking about planning and zoning. Where does the authority come from? Well, first actually comes from the federal government, right? Because you had the 1920 Act, right? 1920 planning, federal planning, zoning, planning and zoning act. But then we also have state and other. The state really is what creates the power. So the Michigan Planning and Enabling Act and the Michigan Zoning and Enabling Act, and PAEA and ZAEA, some people would say, is where the authority comes from, where it's delegated, right? In the sort of federal system. The power is delegated from the state, to localities, to counties, to zones, to plan and zone. So separation of powers, we're going to get into this a little bit more, and I talked about this with Chris and also with Mike, just as an aside. There is, we're going to talk about this in terms of sort of trends that we see, right, in terms of what is the role, and when it comes to zoning in particular, what is the role of the board, what is the role of the commission, and that can vary from community to community. In this case, right, in the case of Bedford, we're really talking about 3 things for the board specifically, right? Enacting laws, adopting a master plan, adopting budget, appointing boards and commissions. Any other examples? What else the board does?
What ordinances, police power.
Police power, right? Police power, or so making law, that goes into enacting laws, right? Yeah, right. So, do you guys deal with special land uses?
At the board level.
At the board level.
With the board or?
Not as a question.
Final approval.
So you do final approval stuff.
Do they? So special land uses do go to the board for final approval?
Yes.
Okay, because that's not always the case.
It is here.
It does? Okay, all right.
Everything does.
Okay, all right. Okay, so that, all right, that's important to know. That's not always the case, and that might be if that's working for the township, then that's great. If it's not, it might have a conversation down the line, right? It's not necessary, per the, zoning or planning enabling act for the board to have a sort of second review of, special land uses or site plans. However, a lot of communities do that. Just putting that out there. So the zoning board of appeals. So we have the township board, which is the legislative body, right, making laws. The zoning board of appeals is a quasi-judicial body. What does that mean? They're adjudicating specific things, right? And there's three main areas here. Ordinance interpretation, just a sort of general catch-all. If there's a question regarding an ordinance and it's something that, can't really be figured out at the staff level, an applicant has, or the staff has the opportunity to put it towards the ZBA for interpretation, right? To put it towards the appointed body to get, have sort of more heads together on the subject.
It also gives you a final official ruling. Right. So someone, if you have, someone comes in, they're an applicant or a property owner and saying, I think the zoning ordinance means this. And your zoning administrator says, I think the zoning ordinance means this. The planning commission says, I think it means some third thing. Now you're tied in knots, right? The answer to that is you go to the zoning board of appeals and their answer is fine. Everyone else is wrong, the zoning board of appeals is right, in this case.
So if you have something that's coming up, right, over and over, and, you don't necessarily, if you're not gonna have time to go through the amendment process, it's another potential route. You can decide, sometimes an amendment process is more useful, but if it's some very specific question that kind of keeps coming up, that is an arena for the ZBA to handle potentially. Appeals. All right, quick question, little pop quiz. What are the grounds for an appeal and the grounds for a decision based on an appeal? Let's start with this. Where is the appeal coming from? Who's it coming from? The applicant? The resident. Could be an applicant, right? The applicant, right?
Yeah.
And what is the applicant saying when you're appealing?
They're seeking relief from the specific
They're questioning.
criteria in the ordinance.
Yeah, they're questioning the zoning administrator's decision.
Yes.
Okay.
Yes. When we're saying appeal, it's distinct from variances, right? An appeal is an appeal of a decision that is made at the staff level, right? Or at the consultant level, right? Whether it is a feeling that they, didn't get a fair, shot, that they weren't listened to, or they felt it was a misinterpretation, right? Or they just don't like the decision, right? They can appeal for any reason. If something is denied at the staff level, if it's an administrative review, right, they can appeal it. Now here's the harder question, right? So, ZBA folks. Let's give a concrete example of an appeal. Yeah.
Well, I actually have an example.
Okay.
So actually, so it came up last night.
Okay.
So we have another community we work in, and they have a rule in the zoning, or two rules in the zoning ordinance, that if you're trying to build a duplex, you must have 100 feet of frontage, and you must be on a major road, right? Last night, their planning commission denied an application for a duplex because it had 100 feet of frontage on a non-major road and only 80 feet of frontage on the major road. It's on a corner lot, right? And the applicant said, well, I got 100 feet of frontage on this road. And they said, no, you don't have it on a major road. Now, these are two different lines in the ordinance, right? So that applicant is now going to appeal the planning commission's decision. Now, this is overlapping a little with interpretation side, right? But because the planning commission has now made a decision, and the applicant says that decision was wrong. He's not saying, I want a variance from the ordinance. I know that though I'm violating the ordinance, but I want to be allowed to do that, which are variances. He's saying, I think you're wrong, and what I'm doing is allowed, and I'm going to take that up to the zoning board of appeals and see if they'll overturn it. Right? So that's lucky. It just happened last night.
In the ordinance it says and, right?
It says it's two different lines. You must have 100 feet of frontage. You must be on a major road.
Oh, okay.
But it does not
I thought you
say.
said and.
Yeah.
So
Okay.
those two things have to both be
Okay.
true. But does the 100 feet of frontage have to be on a major road? Is the
Right.
question.
Right.
Planning commission says yes. applicant says, I think they're wrong, I'm taking out the appeal. Right?
So that's a perfect example. That's like textbook, right?
Yeah.
That's exactly something that would come. And as Chris's point, it doesn't necessarily have to be established. It can be a planning commission decision too, right? Right. It can be any official decision, right? So that's another thing to be if they felt that there was a violation of procedural due process, and we know what procedural due process is. I don't like your application. Get out. Right? It's not good for our town. No. Right? Someone can appeal that. That's an example. Substantive might be, yeah, I mean, that's sort of what it says, but it's not really what it means. Right? And it's kind of an arbitrary interpretation of what's there. So that's why we say it's quasi-judicial. I can't talk today. Because it really is this adjudication of the law, which is why ZBA's role is so important. You might not meet every month, but it's really, really important what you guys do.
Now, there are a couple things that can't be appealed.
Oh, let's talk about that.
Yeah, so subjective discretionary decisions can't be appealed. So a special use, that's a big one. That you can, applicants can sue, but they cannot appeal to the zoning board of appeals on a decision of the township board regarding a special use, because that's a discretionary approval. They have criteria they're supposed to use, but ultimately it's their choice, right? Rezonings cannot be appealed, because that's actually a legislative thing. You're actually changing the zoning ordinance when you do a rezoning.
Right.
So that can't be appealed either. So appeals are only possible when there's a specific objective section of the ordinance and there is a right or wrong answer, and the ZBA to determine the right or wrong answer.
But they can sue.
Yes. So we don't talk about lawsuits all night, but it does come up.
Yeah.
We're not lawyers. We always have to give that disclaimer. We're not lawyers, but we work with this stuff, so we see how the legal aspects play in, right? And one aspect is that there's a legal principle that you can't sue unless you've exhausted all of your township remedies, which is to say, if you don't like something that happened, you can't go straight to the judge. You have to go to the ZBA first. That's not true of special uses, rezonings, discretionary approvals, right? Or legislative things. I don't know if you guys have had anyone petition for a zoning amendment anytime recently. It's not super common, but it is a thing that can happen. It's a right that residents and property owners in your township have, which is to say, much in the same way they would say, I want my property to be zoned something different, and they come in for a rezoning, right? They could say, I don't like this line of the zoning ordinance, and I'm going to petition you guys to change it. And if someone does that, you are obligated to hold a public hearing on what they want to change it to. You're not obligated to say yes, but you are obligated to hold a public hearing on that, and your decision then is not appealable to the ZBA. So,
However, I just want to say, it is appealable to the local court of jurisdiction.
yes, that's the kind of thing that we'll go straight to court if
Yes.
someone wants to sue about
Yeah,
it.
this is where I offer a cautionary, sort of moment to the township board, right? We're discretionary, and, Chris and I can go back and forth on this a little bit, right? Because we're talking planning law here, we're not talking criminal law, right? There's a lot more, vagueness here. But you as the board, yes, we're talking about discretionary. But if you are denying something because one angry resident gets up, right? And the planning commission has voted, I'm just thinking, it's kind of a hypothetical, but it also kind of happened, not in this community, some another community, voted, unanimously in favor of it. But, on second reading, it gets thrown out, right? Now, that's not to say it's a procedural issue, but to say the applicant does have the right, if they feel that the judgment was wrong, that there was an error in judgment, right, on the part of the legislative body, to appeal that, and it would go to the court, right? The law has been made, it's been set, that they can't appeal that. So I always sort of offer this up when it comes to special land use or any, special land use or any type of, really any type of sort of second view. It's when the board is getting something, right, you have to, it's tempting to look at sort of something that's sort of like, well, this is the second round interview, right? This is your second round interview for special land use, or it's your second round interview for the rezoning. Not exactly, right? The planning commission has already been delegated much of that authority, right? There has a lot of weight. That weight has to be considered, right? And, so to sort of view something, well, yes, they said this, but we don't like it. I just offer that as a cautionary tip, because why do you have a planning commission in general, right? Why would you even have that? If you're just gonna arbitrarily decide, why do you have zoning, right? So you're still, bound, we're all bound by the same laws, all the same set of laws. So, I just kind of, put that out there. Yes, you have the power to sort of overturn a decision, but I, in generally, when I sort of talk to these things and I advise clients, I say, there is a set of, by having the planning commission, you are deferring in many ways. There's a deference there to that decision, to a certain degree, right? And what you should be looking for are errors in judgment, misinterpretation, right? Misinterpretation of the master plan. There still has to be some sound basis by which you're making a decision, and it should not be, well, John Smith, who owns a business on that street, got up and said he didn't like it. That's a factor, right? I'm not saying it shouldn't be listened to, right? Just like we have great public comment, but it's a factor. Anyway, just putting it out there. Sorry.
No, I think you're good. I thought you should listen to the
Yeah,
planning
we are.
commission.
Okay, sorry.
Planning commission slide.
Yeah.
So skip.
Yeah, oh, here we are, planning commission. Ordinance administrative functions for the zoning administrative planner. So, obviously, planning commission, ordinance recommendations, budget requests, zoning approvals. So when I get up and make my recommendation, the planning commission is absolutely required to take every bit of it, right? And listen and agree with 100% of what I say, right? No? You sure? Really? But I'm right. I'm the guy you hired. So you should listen to everything I said, right? Yeah. So I always also tell this to applicants. I say, listen, I will walk you through a lot of time applicants will kind of view me as a planner as like their advocate. I'm like, I'm not your advocate, right? I'm trying to set you up for success, but I am not, my fiduciary responsibility is still to the township, right? And I want to tell you this, I could write my report and I could sprinkle it with gold leaf. The planning commission has zero a requirement to take any of my recommendations, right? They hired me. There usually will be a deference, but are they required to adopt what I say or the ordinance that or the motion that I recommend? Absolutely not. I always caveat that. Do we have a new zoning administrator?
Yes, we do, Karen.
Temporary intern.
Oh, hi. Welcome.
I
know I saw
wrote
your
down
face.
my questions.
All right, good. Crystal answered them all.
Okay.
All right. Any questions so far?
Yes.
Yes.
I've had experience in a couple different formats with the Planning Commission and the ZBA. Is there anything in your structurally going into the PC that should just skip A and go straight to ZBA? It's always my belief that people were given the option of 2 hearings, and I say hearings, 2 meetings. And if you skip the PC and go straight to the ZBA, there's no one that they can appeal to. So that, and if it's spelled out in the future slides, I'll hold on that thought.
No, I think that's a good question because we just
There's
talked
always
about
court.
we just talked a
after the
lot.
ZBA.
Yes, we just talked a lot about appeals. We didn't get a lot into variances, which is actually what's most common on ZBA, right?
Mhm.
Is the request to violate the ordinance, which you are allowed to grant through the variance process, right? The reason I bring that up is that to answer your question, it depends on what's being proposed, right?
Mhm.
Somebody who intends to follow the ordinance, but is doing something that requires a planning commission approval, or even a zoning administrator approval, right? Because there's a number of things in the ordinance that you could just, it's good, right? And all of those things, for the record, are going to be things that are objectively clear, right? The house has to be 25 feet from the property line. The house is 26 feet from the property line, so we're okay, right? No, that's not, nobody's gonna haggle over that, that's what the tape measure says, right? Zoning administrator can sign off on things like that. Planning commission is gonna be more along the lines of the McDonald's needs 25 parking spaces, and we're gonna make sure that they're safe. It's a little more complicated, so it's the planning commission. If you go through one of those zoning administrator or planning commission processes, intending to follow the ordinance, but get denied, even though you think you followed the ordinance, you can go to the ZBA, just as we talked about. And that's one where, yes, you don't skip straight to the ZBA. You have to go through the process, because you've gone through the process with the expectation you're going to be approved, because you were gonna follow all the rules. And now you found out that their interpretation of the rule is different than yours, and you were denied, right? If you go into a process saying, I don't wanna follow this rule, I have special circumstances, and I don't need to follow this rule, and here's why, you go straight to the ZBA, right?
With a variance.
With a variance. Because you were never intending, if you went to the planning commission, frankly, it'd be kind of a waste of everyone's time, because you come up in front of them and they'd say, your setback is too small.
Right.
And, or you, it's not even a survey, your setback is too small. And they're saying, I don't wanna change that, I'm going to the ZBA. So let's, just to save everyone time, you can take those straight to the ZBA, and they can ask for that variance. Now, we're gonna get into variance criteria later, so I won't give it too much there. That's the answer there, depending on what they wanna do, you may not have to do the planning commission first.
Raphael, if I could interject, Karen, I'm just gonna use the example that I think that you're looking at. If you have a, conditional use or special use that needs to go before the planning commission, that you also think may need a variance.
Right.
They need to go to the planning commission first for their use permit, and then they would need to seek relief from the variance, because you can't go to the ZBA to get the variance when you don't know if you're gonna get approved.
That's a good point. So
In
there's
case
a
in point, what we're dealing with right now.
There's kind of
figured that's what.
a pyramid here, actually, because a special use permit is the question of, can you do this thing in this location, right? Can I put, I'll give you some McDonald's, a drive-through McDonald's in this location? But aside from everything else. So if the answer to that is no, all the rest of it is moot. Doesn't matter if your setback is too small, the answer was no, so there's no need to go to the ZBA. So in this case, ordinarily, especially in a community like you guys that does special uses as 2 meetings, right? Recommendation by the planning commission and final approval by the board. We would frequently recommend going planning commission for their special use recommendation, so we have some indication that this is actually allowed here. Then the ZBA for the variance, so we know how the site is gonna lay out. Then the board's final approval of the special use, then back to the planning commission for site plan approval with the variance taken into account. Make sense?
Yes.
So if you when you tell somebody they're gonna do all that, they're gonna, which awesome. But they are asking for a few different
process.
That would, yes.
In that scenario.
That's how you would usually recommend you do that. Just answer, think about how big of a question each of those pieces of the process is going to answer, and do the biggest question first. Because if there's a question along the line where the answer is no, but everything else moot, let's do that one first. Then we'll deal with the rest. That was a yes.
That's a good way to think of it, thank you.
Similarly, by the way, if you have a special use and site plan for the same thing on the same agenda, which is pretty common, right? You always want to do the special use first, because there's no reason to dive into site plan details if the special use isn't done.
Told you it was good. And did you also, I kind of, if I didn't catch it, Chris, but you also mentioned like when you have a conditional approval too, right, for a special
Yes.
use, right? And it can be,
Yes.
so when it comes out of the commission, the condition on receiving a variance, right? You can have that language in the motion, right, also, just to keep that in mind for the planning commission.
Yes. We could dive into some detail on special use conditions if you want us to.
All right. Team connections. All right, just review. So township board adopts rules, appoints boards, commissions, hires staff, funds, training, development of plans and ordinances. Planning commission staff develops plans and ordinances, applies rules, can approve developments, makes recommendations to the township board. And the ZBA interprets rules, developed by the planning commission, grants waivers from rules, i.e. variances. All right, so this is exactly what we're doing right now, so I don't know if you have to talk about this, right? Planning and zoning process is cooperative effort. Joint sessions like this one are a must. Constant orientation and training, right? This is all stuff, obviously, you guys already, you've been doing it now, for a year and a half at least. And then, consultation planner, with the planner and attorney, when necessary. Always recommend, to get both opinions.
Now, I'll just chime in with one thing there. and that is that we're talking a lot about formal processes, formal meetings, things like that. There's an element of this collaboration that can be informal. And that's particularly true when we're talking about master plan and we're talking about either new zoning ordinance or zoning ordinance amendments. Where you cannot have a discussion with a forum of the group outside of the public, and we'll talk about the Open Meetings Act. But you can say, all right, we're gonna send this over to the township board members and have them give us any comments they have in writing, and we'll bring those written comments to the next planning commission meeting. That's not a formal process, that's not an approval by the township board, but what it is now the planning commission has the board's thoughts. And so there's no surprises when there is a formal recommendation and somebody's on a formal board agenda. Also, it is in bounds, allowed, if you're not a member of a board or commission, of a particular board or commission, you're a member of a different one, to come to the meeting with public comment. Right? These things are allowed too. So these informal ways that you collaborate, so long as you are not getting a quorum of your board together outside of the public eye, because that's a big number.
You can't even like go to dinner.
Yeah, I mean, like exactly. I don't know exactly who's going to stop you, but yes, basically,
Yeah.
you can, or you definitely go to dinner. You cannot talk about business,
Yeah.
right? And the other one is
We've had a challenge with that. I work for state government. We've had that challenge before.
Yeah.
If there was more members of a specific committee who went to dinner as a group just to go to dinner.
I actually
That's been an issue.
I used to work with a community where the ZBA would go to the bar across the street after meetings. And they got in, and their attorney was like, guys, that's kind of, so they said, no, here's what we're gonna do. At the end of every meeting, before we adjourn, the chair is gonna stand up and say, the ZBA will be reconvening the meeting across the street at the bar. And they would literally do this, across the street at the bar, in 15 minutes, and the quorum of the ZBA will be present. And then, okay, all right, the quorum of the ZBA is present, everybody knows, if you want to attend this meeting, you could go to the bar.
Like to see those
But yeah.
minutes.
Yeah, I don't know that.
Does the
that-
motion count? After how many beers does the motion
Yeah,
count?
right.
That's the next question.
Yeah, see, I don't, this is where you get into a little bit of a gray area, but the hard and fast rule is you absolutely, if you have a quorum together and you're talking about business, the public must be present and they must be notified the meeting is happening, period. A more common issue is email. And I'm sorry, because I'm probably doing
No,
something related,
that's good.
but more common issue is email, because a lot of communities, probably you guys, send things out to the whole group by email, and that's fine. But where it comes in as a problem is someone hits reply all and says, hey, I think such and such about this agenda. You can't do that.
BCC is your friend.
I don't even do that.
No.
No. Reply, just reply.
Yeah.
Not
But if
reply
they
all.
avoid the reply all,
We're pretty well, the chairs are pretty well versed in making sure that that's on the bottom of every.
okay, here you go. Or that, here we go. Yeah, yeah. There's a lot of ways around it.
I had one planning commissioner, gung-ho, joined the planning commission, so excited to be on it, and he kept responding to the agenda every month with how he was gonna vote on every item.
No.
Dude, stop.
May I ask one question? I think you said that, it's fine for other boards to come to, for instance, like come to the planning commission meeting. And I've been told, just as supervisor, no, don't go to the planning commission meeting. Even if you're there as a private citizen, it can be viewed as attempting to influence the commission. So, I mean, what are your thoughts and what have you seen other communities doing in that? I mean, because
So-
of course we're interested, but, and
Yeah.
it wouldn't be a quorum, but.
So some of it is down to, so legally you're fine if it's not a quorum. Some of it's down to how comfortable everyone is, because you're the boss, right, as a supervisor. Some people don't, they act differently in front of the boss. And so if there's a feeling that that's gonna be an issue, you better take it into account. There are actually communities though, I work in communities where the supervisor is at every meeting and has an agenda item, supervisor's comments. In the communities that do that, I think this is important, they put the supervisor's comments at the end of the meeting. So they're not, this is what I think about all your agenda items. It's usually, this is what the township board is doing and other things that may come up soon, or you may see, or here's what I'm hearing from the county road commission, or MDOT, or a developer called me, or so it's information sharing, not opinion sharing.
Almost like a quasi liaison.
Like a liaison type thing, yeah. So that kind of thing is definitely appropriate, and it is important to share your thoughts on things informally in the ways that are allowed. And the reason I mentioned written comments before is because it's less intensive than being at a podium in front of the public, in front of the dais. But if you send an email saying, I want this included in the packet, here are my thoughts as supervisor on this, which I know is going to come up to the board. And so that you know that I have concerns with X, Y, and Z in this zoning ordinance that I'm working on. Now, rather than be surprising you with them after you guys do a bunch of work and send it up to me, and I'll say, no, I have problems with this, right? You are allowed to do that, and I actually recommend it, but you have to stay within those limited bounds, right? And also think about the sort of soft aspect of what it feels like when the boss shows up, right? So yeah, I think that's important to take into consideration.
And I mean, I think, and just to piggyback on what Chris is saying, you know, getting into certain habits that there's an expectation, right, it can be a good thing versus the supervisor shows up at XYZ public hearing, once in a while, and then it becomes an optics thing, right?
Yeah,
right?
I've chosen this
Yeah.
to intervene on,
Yeah.
but not that.
Right.
There's that too.
I can think of one community, which shall remain nameless, where that does happen, and well, it's the mayor in that case, who shows up and it just happens to show up on critical things that, they want their voice heard on.
Isn't that kind of a slippery slope though in the case of Bedford, because the board obviously does have the right to the final say.
Right. So, I mean, I think, so my
I
thought.
mean, not that I
yeah.
think we have that problem here, right, because I don't.
Right. Well, I think, so, I mean, I think we're.
As far as trying to lead the planning commission
Right.
in a direction one way or another.
Right. I mean.
In this instance, they do have the final say.
I'd be a little bit more cautious on a yes or no type question.
Okay.
But rezoning a special use, if the advocacy from the board is, I don't think you guys should approve this, I'm a no vote against the board. I'm not saying that that's like, you have a legal problem there or something like that. I would discourage you from doing that, right? I would encourage you to do it when it's, hey, this page of the master plan, or this zoning amendment, and it's a legislative function.
Okay.
Like, hey, it's like participating, so one of the things that we say in these trainings is like, planning commission and board are not a bicameral legislature. You're not the House and the Senate. The planning commission is below the board is final, right? But the planning commission is supposed to do the legwork because the board has to do other things like figure out the budget, right? So the planning commission is supposed to do all of the nitty-gritty writing and revising, and then they say, this is what we've come up with, and give it to the board. Ultimately, the board is final. So when it comes to something that's complicated and nuanced, getting the board's input is good. And up or down, you really shouldn't be coming up and just saying, you should vote this down, or I'm going to vote no at the board level. That's not helpful, right?
Also,
mostly it's just Joni, like the solar ordinance is a prime example, like communicating what's happening at the state level to the PC, so they know what's going on.
That's definitely important.
That's absolutely appropriate. I mean, that would be like, supervisor's report to, right, even if this comes in the form of a letter, because it would be, Joni's job to keep abreast of what's going on at the state level, right, so that they keep the rest of y'all informed. I think that's a perfectly appropriate.
That's a very, very good use.
Raphael, Chris, and Joni back here, wherever you are.
Right behind you.
Okay. I remember back in the 90s, Tom Sproul used to come to our planning committee meetings. He didn't say anything, but he sat in the back row, and he was just here. Like you were just saying, Stacy, if there was something very important that he had gotten from one of those meetings in Battle Creek that he had to attend as a supervisor or something, he might mention that. But that rule about supervisors not attending the meeting, I don't know when that started, because Tom used to come.
Yeah, it was our attorneys now, the municipal group we've got, staff who said,
Okay.
and I felt more comfortable doing it as a trustee, but then when I was moved into the supervisor role, he said, oh, really be careful.
Yeah.
And it's not that the supervisor is the boss, just
Right.
to clarify that. The supervisor has one vote on the board
Exactly.
also.
But the supervisor appoints.
But they appoint, and then they really kind of control the agenda that's gonna go out, so, yeah. So he just said, if you go, even as a trustee, he said, you gotta be very clear you're there as a citizen. You're not there
Yes.
as a board member.
And that's why I said he did not contribute anything to our meetings.
Yeah.
We weren't intimidated by him either, so. Guess it is a slippery slope in a way.
Would that be where the board would lean into their liaison?
Yeah.
And
That too. That
hypothetically,
too.
Yes.
Yeah.
hypothetically, the supervisor's report could be read by that liaison.
Right.
Absolutely.
And
that's-
that kind of
And the
puts
liaison,
hands.
the liaison does report back to the board, so we do
Yeah.
get that information,
Mhm.
soon afterwards. It's not that we're, it's a vacuum there at all, but.
I mean, obviously, Raphael, our liaison on the PC has a role, but I mean, their primary role is to be the go-between between PC and the board.
Yeah.
Right. And I also want to say, just speaking to the sort of deference thing that I was raising earlier.
Yeah.
You as the board, question, do you have to vote yea or nay on something? Or is there a third option?
The board
The
of
board.
trustees, it's you have to vote on everything unless there's a clear conflict of interest.
No. I'm saying, do you have to vote yes or no? So
You cannot abstain if that's what you're doing.
okay, sorry, let me explain. Special land use is voted, let's just say unanimously through planning commission, right?
Okay.
But there's a question on the board. The board is a hung jury in certain ways, right? Whatever, and is there, do you have to hold is there have to be a yea or nay vote, or could there be a different motion?
You could motion to send it back to the planning.
Thank you. That's what I wanted to say. That's exactly what I wanted to hear, right? You can lean on that deference, right? Lean on that nitty-gritty, on that expertise if you feel that this is above my pay grade, right? We don't know. Or we think that there are certain things that that the planning commission didn't catch and we want them to look at, right?
And
So,
the motion could be just to have a second look.
yeah, exactly.
We've done it, yeah.
Okay, yeah, I just want to put that out there also. Again, that the sort of, there's a tendency to kind of think it's like, again, like first and second round interviews, right? You get the job, you do that. That's not what this is. A special land use application is not first round interview, planning commission, second round interview, board. Oh, sorry, didn't get it, right? There is this back and forth. There is this conversation, right? All right, awesome. All right, this you're familiar with. Master plan, zoning ordinance. We don't know what a master plan is. We haven't spent any time on that. So, it's gonna take a long time, guys. Right. So we talked about it, and you've heard me, talk about this. That there's really, I can think it can be summed up in two things. It's the visioning document. It's also the policy basis for your zone, right? That is the two main things. So again, when you say the presumption of validity, right? Are we being filmed here? We're being recorded?
Oh.
Are we? We are? Okay.
It's not, I'm going out in real time.
Oh, it's okay.
Don't worry
I just want to bash my hometown for a second. Where I'm from, New York City, never adopted a master plan.
Really?
Never has. So, here's my planner bias. I don't believe you should have zoning without a master plan. I will put that on record, right?
It's actually illegal in Michigan. Maybe not New York.
Right.
It is, zoning in Michigan must be based on a master plan.
Right.
Period.
Why is it a bad idea to have zoning without a master plan? What's that? Well, what is the point of
It's
zoning?
liquid.
Yeah.
It's liquid.
You go.
What is zoning really? What is zoning's function at the end of the day when there's no master plan? What is its function? That's the master plan. Zoning just says what you can build where, how much can you build, what your setback is. What is it about? What is it protecting? What?
Your neighbor?
Yeah.
That's the opposite, right? It's protecting your property values. It's protecting whoever has the most influences, right?
Right.
Whoever's got the most, right? That's what zoning really comes down to, right? It's not, right, and maybe other things too that we don't like to talk about, like racial biases, right? All you have to do is go back to the original Euclid v. Ambler decision, right, which everyone thinks is the beginning of kind of separation of uses, but really we already understood, and look at the line that says that apartments are mere parasites, right? That was written by the Chief Justice, okay? So zoning in and of itself doesn't really have a leg to stand on, in my opinion as a planner, The whole point of the master plan is you have a public process where you get input, right? You have back and forth, you go through a bazillion different future land use plans, right? You have a visioning for the community. That is why it's the policy basis for your zoning, right? Because you've had this process, right? And that's why you also have to review it every 5 years. What I would say, recommend doing this stuff, well, you review your master plan every 5 years by statute, you should really review your zoning, right? So, I've heard it said that the zoning is sort of the legs on which the table of the master plan stand. I think it's actually the opposite. The master plan is what supports the zoning, right? That's the basis. So, anyway.
Yeah, I think there's like I think Raphael got into some of the high-minded stuff, but there's a very high-minded aspect to this, right? Zoning takes away property rights, right? Without zoning, you can build wherever you want, wherever you want. That's more rights. In order to take away rights in this country, you have to have some sort of public purpose, right? And that public purpose is your master plan. We are trying to achieve this vision of the future together. And this process has been inclusive, and it's been democratic, and this vision is sort of agreed upon as a consensus of our community, and now we are able to use zoning to get there. Now, zoning also does do the things that came up, right? It protects neighbor from neighbor, right, and things like that. But, as Raphael said, if it's not building towards a goal, it's arbitrary. It's just rules you make about what people can build on their property. This has come up with us in a number of communities. There's a number of rural communities, like you guys, that have wind and solar proposed, right? And they, unlike you guys, they don't have local zoning. Some of them don't have any zoning. Some of them don't have, some of them county level zoning, stuff like that. We're getting a lot of calls at our office about, okay, how do we set up local zoning? We need a local zoning ordinance. But first, you need a local master plan. Otherwise, you can't do it.
Yep. Yeah. And this is happening, right? And Bedford already had their own zoning. This is where we see this across the board, and this is why we had our meeting with consumers, and we were yelling at them for 2 hours, not that it really did much. Say, you have to understand is that the process here is when organization or developer, whoever it may be, consumer, anybody else goes through the county, right? And at this point, the town, XYZ Township has deferred to the county for their zoning, and this process goes through. What the township, by taking back their zoning, by taking back their master planning, is saying is, look at that last line, preservation of community character. We do not believe you are representing our community anymore, right? You don't represent our values as the county, so we are going to take back this zoning, right? So this is why my job is going to be really hard, right? Because I'm going to have to go, right, and be, how do I represent 11 townships, right? Well, I chose the job. So, I mean, this is, just something to keep in mind, when we think about zoning, we think about master planning, right? That community character, community identity is a really big part of it, right? It has meaning. There's teeth to it.
When McKenna prints up that master plan book, would you have them put 2024 on it, please?
Well, yes. Well, it will. Yes. Well, when it gets adopted. When it gets adopted. What do you think? You think it's going to be big until 2024?
She's being
I'm just giving us another year.
Oh, you're just like, oh, okay.
Before you have to do it again?
Yeah.
Oh, yeah,
it's like post dating checks. You can't do that anymore.
Oh.
Right?
Well, you can,
So-
they don't know.
Won't go there. Anyway.
So actually, this is a little thing, but it will come up. The master plan is adopted the minute the board votes on final adoption, right? It's in effect immediately. And that's because the master plan is not the law. It's extremely important, as we just talked about, but it's not a law, it's a policy document. The zoning ordinance has the force of law. When you adopt a zoning ordinance or a zoning amendment, it has to be published in the newspaper and doesn't take effect until at least 7 days after that publication. And there's an opportunity for a member of the public that disagrees with it to file a protest petition and put it on the ballot because it's a law, right? Now, I mean, we can get into the details of that, but my point there is that as we move forward, and we're looking at adopting the master plan in October, right? This is when we're scheduled to adopt. But then we're going to work on the zoning ordinance. And we get to a zoning ordinance, and you get to the very end of that process, and we do final adoption. It is reasonable to say, all right, this is adopted, but it's not going to take effect until, say, January 1st, to give everyone time to ramp up and be ready for the change, rather than have it happen overnight. A lot of communities do that, like not in their master plan, but zoning ordinance, that it's just going to take effect next year type thing.
And publication. do not miss your publication dates. I cannot stress this enough, okay? We had one community who shall remain nameless, not this one, who literally adopted ordinance by ordinance, a new zoning ordinance, did not publish any of them in time. It was all invalidated. Over a year's worth of work down the toilet, taxpayer dollars down the toilet, because they didn't publish in the record, in the 15-day time frame, right? Or, you know, in case of a zoning amendment.
Me too.
So just, I'm sorry to, you know, stand him. It is not a minor thing. It is a technicality that will crush everything, I know, right? And also, when people, if someone does sue you, what is the first thing they look at? They look at substance. Do they look at substance? They look at procedure. Low-hanging fruit. Where'd you mess up? Why, what didn't you vote on? When did you vote? When was it enacted? Right? They can get you on procedure, they don't have to go for substance. Substance is a lot harder to prove in court, right? So, put that out there, you know, publish in time. Can't say it enough. All right, I don't think I need to get this. We talk about master plan content, purpose, profile, existing conditions, visions, goals, strategies. Let's, Chris, is there anything else you want to say?
Should we talk about future land use and how it relates to rezoning?
Oh, yes, yes. Please.
Yes, obviously you guys are right about to adopt the new master plan, it's exciting. And
An awesome master.
yeah, and then we're gonna move into the zoning ordinance. And actually very important to these folks is that we've been working as part of this first draft zoning ordinance that I think you sent it to him, right?
Yes, yeah.
Mike has it.
I'm sure Mike's had 24 hours. I'm sure he's read it. He could probably repeat it verbatim.
I've looked through 2 pages.
Yeah.
One of the things we'd like to do with you guys is adopt a new zoning map. Because your existing zoning map has some issues.
The split
Yeah, for sure.
Split between what is not clear.
And here, in between now and when it's adopted, my decisions or that of the PC set precedents for the future
Yeah.
on those split zones. So
Yeah.
I'm extra cautious on.
Well, the good thing is you're not going to have those for much longer.
Yeah.
Assuming you guys go with the direction we're recommending.
The draft ordinance does eliminate the split zone thing.
Yes.
It tries to create more clarity. But my point here is that we worked on what would be a new zoning map. And the zoning map, if you look at it, is going to be pretty similar to the master plan map or about
Future land use
map. Yeah.
Yep.
But it's not going to be exact. It is going to use this sort of philosophy that everything in the township is zoned for agriculture until somebody asks for to rezone something else, right? And there's a number of places throughout the township, we're standing in one, that are obviously not agriculture anymore, we're reflected down on the zoning. But there's going to be parts of the township that are master planned for something that's zoned for agriculture. And reason for that is that if someone owns property in those areas and they want to do what the master plan says is the future of that, they come to you for a rezoning. Now that rezoning should be approved because it's consistent with what the master plan says, but they won't be zoned that until they ask. That's kind of the idea. In some cases, this is going to look like spot zoning. Right? Spot zoning is probably a term we've heard. It's a very sort of common term out there. That is a thing. It is a concern. It's not a killer because when it's like, well, we have this area, and this area is going to be for businesses, but right now there's no businesses there, and the first business comes in and wants to get that commercial zoning, that's not spot zoning. That's just incrementally getting to where the master plan is. Right?
That's the whole reason why there's a zoning plan.
Yeah.
The zoning plan is explicitly saying what is the relationship between the future land use designation and the zoning options you have, right? So I can't live in RRAOS, right? Right, rural residential, agricultural, open space, and say, I want to rezone to I-1. It just ain't gonna work. You just really can't do it. I mean, you can, but again, lawsuit. That's just the thing, right?
Now,
So,
you're being arbitrary, that is spot zoning.
Right,
If you're just letting people go to whatever zoning district they feel like, right? And then you end up with a hodgepodge.
Right.
So, that master plan map, that future land use map, as planning commissioners, that's gonna be very important to you. Because that's gonna be, all right, what is the future of this piece of property? When someone comes in and asks for rezoning, and I think we tried to set it up. And the nice thing about the master plan and zoning ordinance kind of back to back is we're trying to set it up, so it's actually gonna be pretty simple, right? Industrial in the plan, industrial in zoning, although I think we did the enterprise thing, right?
Yeah,
We've
with
got
enterprise.
enterprise, which gives you commercial or industrial, which gives you a little bit more flexibility.
Right.
But,
This uses a lot of flexibility.
I mean, but certainly, are we talking about farmland preservation or natural preservation, or are we talking about building 100 houses? And you guys had a lot of discussions, right, about that in the master plan, and those are gonna be 10 years from now, you're relying on those discussions to make those decisions. So I wanted to bring that up. Otherwise, yes, everyone's been through this just recently, so.
I think we talked about this, so we just sort of
10 years from now, you're relying on those discussions to make those decisions. So I wanted to bring that up. Otherwise, yes, everyone's been through this just recently, so.
I think we talked about this, so we just sort of saw where we're at. So August 15th was the final day of public comment from the outside agencies. We did not receive anything beyond the initial 3 responses I think I emailed Mike about, saying, yeah, we got it, thanks. And that's fairly typical. We always get, those sorts of responses, but.
We did hear back from the Calhoun County Planning Commission.
You did? Oh, okay, cool. How interesting. All right, that's good. So you did get some.
I have a copy.
Before you go. Yeah, sure. Crystal sent it to me. No, I'm just kidding. So obviously, we have the public hearing scheduled, right? And the public hearing is, all intents and purposes, that is the apotheosis of the public, inputs. Period. Right. And after that, legally speaking, right, policy-wise speaking, you feel the sense is that okay, the public has now spoken, right. This recommendation has been. This is a very solid recommendation, right. Assuming that is towards adoption, right. Assuming that that's how the public hearing goes, right. So again, just kind of going back to the whole deference thing, right. Public hearing is very serious business, right. It's not just a technicality, right. Once that's been held, there's a reason why it's called an adoption hearing, right? If there's going to be a stopping of the process at that point, there really needs to be a real good reason why, right? A really substantive reason. Because at that point, the public has had their 63 days, there's a public hearing, anyone can show up, all right? There's opportunity for individual board members to say what they need to say, right? So again, just speaking about this, that's why, and I talking to Chris about this, he mentioned something I thought was very smart, which is, if you're a board member, you can sort of use this opportunity, right, to submit your comments before it gets to the adoption hearing.
Put it this way, in the context of the master plan you're working on right now, when's the public hearing?
September 26th.
Okay, so cool. Make sure that's on my calendar. If we can make changes between now and September 26th without any sort of repercussions on the process, because we've created the distribution draft, that went out for distribution, comments have come back. We can make changes before the 26th, we call that a public hearing draft, right? And that can be different than the distribution draft. As Raphael said, once you've done the public hearing, there's been a recommendation made. If you're gonna make major changes, not typos, but major substantive changes, you have to hold a public hearing. So, and that goes for zoning amendments, zoning ordinances too.
Would we have to do that, let's say, we have the public hearing, and we have residents say A, B, C, and D, and then the planning commission says, well, we're gonna go ahead and change this line or that line, or a few words here and there. Is that something that you guys would consider a major change? Or
If you do it at the public hearing,
right,
and your motion at the end of the public hearing is you
to
recommend
approve
this to the
with those
board
changes.
with these changes,
Right.
that's fine.
Right.
Yeah. And then it becomes the draft for board adoption. It's just having that clear, when you get to the end of the process in particular, this draft, then this draft, then this draft, so that everyone knows what the most recent one is, and the public is covered.
so if there's any changes at that public hearing, that motion at the end needs to include said changes,
Needs to reflect
whatever
that.
they are.
Yeah.
Whether it's 1, 2, 10,
Right.
25.
Yeah, or if it's 25, you
Hopefully
say,
0.
we're at table this, we're
Right.
gonna make the changes and come back, and you don't hold public hearing again then, because you announced to the public, you're gonna make these changes and you have to come back to us. So
Okay.
it's once that planning commission recommendation has gone through, and we get to the board adoption meeting, if they have serious changes, as what Raphael said earlier, the vote is back to the planning commission, full vote.
Right.
So, for efficiency's sake, that's why we want to use the remaining portions of our comment period, which the legal minimum was August 15th. You guys are doing this September 26th, because it was right after the planning commission. Let's get any, I don't know if there are, but if there are comments from board members, you guys want to make on the master plan, please provide them to our office and we'll make the changes and highlight them on the 26th at the meeting. And let everybody know that that's what the board is requesting. That's the type of informal input I was talking about before. Getting that in now so you guys are ping-ponging the plan back and forth at the end of the process.
And I mean, obviously, if there were any changes from the board, they would have to loop in the PC, so we would know what those changes are as well, obviously.
Yeah, again, rather major substantive things, but yeah.
And I mean, this is why, and this is why, Chris will be, the same kind of, contact we had back and forth, like, that's gonna be Chris's role, to let you know, so that there's, I don't know if we had sort of a formal rewrite committee, but, and obviously, the players have changed over time, but, there essentially is that, you don't have a quorum, you've got the planner, you have, the planning commission chair, right, you have, board liaison, that becomes the sort of the rewrite committee in a way, right? So that's just something else to keep in mind. It's a way to kind of move through the process, again, without having to kind of go through and everyone show up and vote every single time, right? You can get the stuff there, you can mark it up, and then that could be voted on.
Right. Yeah, you could appoint subcommittees, just as long as they don't have a quorum of anyone. Right. But that is, yeah, it's a general rule. If you've got something complex you're working on, getting a group that's 2 board members, 2 planning commissioners, or something like that. So we're not a quorum, but there's representation. Is a pretty effective way to do that deep dive writing and revising, and then the board, and then that group can say with one voice, "This is our recommendation." Then you take it to the formal process where it can still be changed.
Yeah.
But now these 4 people kind of stand behind this, and that helps.
But because we have a liaison, your recommendation, I assume, would be to lean heavily on that position.
That makes sense.
All right.
I just want the clarification.
Okay. We're getting you there. All right. So using the master plan, rezoning decisions, capital improvements, environmental issues, recreation. These are the various, obviously, separate sections of the master plan.
These folks have a Parks and Rec plan?
Okay. You do. Yes. Yeah.
Yeah, and for those that don't know, we won't go into, because we could do an hour on that, but.
Right.
That is, you submit that to the state and it makes you eligible.
That's the whole.
So, it's sort of a Venn diagram of the master plan, right? They're related to each other. You can actually make them the same document, some people do. But that the Parks and Rec is, you actually have to submit it to the state for approval every 5 years to stay eligible for MDR grant programs, but that's aside.
You want to talk about the zoning ordinance?
Sure. Yeah, I mean, I think we talked about a bunch of this stuff, but I can talk about this later.
Yeah.
So zoning ordinance, and I think it's important, I've said this a couple times, but the zoning ordinance has the force of law. It is a law. And therefore, the language of the ordinance has to be very carefully constructed, right? And this is also why we have all of these processes for appeals and interpretations and variances and things like that, because unlike the master plan, so we say kind of our business is if we've got disagreements about the master plan during that process, we can always make the language a little bit more vague, or even say in the master plan that we have disagreements and we're going to work on them as an action item. These are all things you do in a master plan. The zoning ordinance, you cannot. The zoning ordinance, this is the rule that you are establishing that everyone has to abide by, right? All the way up. So we've talked about these big picture zoning things, philosophical zoning things quite a bit. So what do you want to have in a zoning ordinance? And you'll see, we provide you guys with the first draft, and we're going to start working on that, revising that, and that process going forward once the master plan is adopted. Definitions are important. You have to define terms, right? One of the things that we try to do with the draft we gave you is define all of the land uses so that people can say, well, I don't know, this thing that I want to do, what is it? How does it fit? Because you're not going to be able to include every single thing people could possibly want to do with their land in a zoning ordinance. Things are have to be put into categories. So by making sure to define those land uses that are allowed, we can hopefully make it easier to put things in categories. Zoning districts, I mean, I think this is fairly new, easy to understand, right? You have a district that allows these uses, has these rules associated with it, et cetera. There are varying levels of complexity, nuance, and creativity on this, or you can just say, hey, this is an agricultural zoning district. That's it, you know. Permitted uses versus special land uses, or permitted uses by right, or sometimes called. This is I'm sure this is a concept you guys work with all the time, improve special land uses. Permitted use by right is, you could do that, period. There may be rules associated with it, but if you meet all the rules, you can do it. Nobody has the discretionary authority to tell you you can't, right? A special use has that discretionary piece to it. You come to the planning commission, they make a recommendation to the board, that answer can be no. Now, it has to be based on the criteria that are listed in the ordinance for whether that's a yes or no, but that answer can be no. So you use the special use tool generally for uses that are okay in this broad zoning district we've created, right? But maybe not on every single piece of property in that entire zoning district, right?
I was gonna say one other thing.
Yeah.
One thing also that you're gonna see in the ordinance, and that, you know, hopefully you guys will continue to develop over time, is, and this is where there, you know, especially with special land uses, there is sort of an interpretive aspect, is every zoning district is gonna, at the very beginning, gonna have what we call intent, right? Intent and purpose. And it's going to lay out what is the intent and purpose of that zoning district. So this is something I also encourage, the planning commission and the board to do when they're looking at special land uses is, obviously you want to look at location, you want to look at neighboring land uses, but what is that intent, right? Don't be afraid to lean on that intent, right? Does this meet the intent and purpose of the district? Even though it's a special land use or as a special land use.
That's a good point. Yeah. I mean, this goes kind of to my earlier example where I was talking about a community that says you can have a duplex if you have 100 feet of frontage and you're on a major road, right? Mm-hmm. And so there's the option to say you are permitted use by right if you have 100 feet of frontage and you're on a major road. Or you could say you're a special land use and you have to have 100 feet of frontage and be on a major road, and we need to review you against these criteria that are more subjective, like your impact on the health, safety, and welfare of the things around you, or how much traffic you're going to generate, or what your environmental impacts are going to be, right? And that's when you, as you write your zoning ordinance, deciding which of the three buckets, permitted, special, and prohibited, right? Not allowed at all. You want to put a given land use in. It's a very important policy decision, and it's going to impact people down the line, right? Development requirements are things like parking minimum, your landscaping requirement, your lighting standards. You could include signage in this. And this is the kind of thing that some communities really dive into hard. I don't know if you guys have ever been to the IKEA outside Detroit. You get off at that exit and it's all business and stuff, but there are like trees and flowers and lights. You can picture all that stuff. It's because Canton Township, that community, their development requirements are like this long. Like if you want to, and they can do that because they're the type of place that IKEA will put the only store in Michigan, right? So they know that if that they can sort of extract that, right? Like we're going to make you plant trees and flowers and stuff like that. And that's great because then it's beautiful. But on the other hand, when you have a small business owner that's just trying to get off the ground and you say, we got to have all these trees and flowers and shrubs and stuff, then it's an issue. So it's a philosophical decision you have to make as a community, and it's something that your master plan can guide you on in terms of how intensive you want to get on these development requirements. The other aspect of that, as I mentioned, parking. Parking minimums are they're not cool right now. Like,
yeah, I know.
They're not cool. But they're out there. But there's a reason for it, right? In some cases, it really depends on your particular case, your particular community, because you don't want. I have an example of this actually. We had in one of the communities we work in, we had a restaurant come in, and their parking requirements said 1 space per employee plus 3 spaces per table or something like that. And that's not the way I like to write restaurant parking requirements, but we can talk about that later. But my point is, they said we're going to have 2 employees. We're going to have a cook and a server. Maybe I should have been more skeptical of that plan. But that's what I said, that's who's going to be on duty, cook and a server. And then I went in there for a sandwich one day, and they had 10 servers and 3 people behind, and there were people parked on the grass, and it was like, this is why we have parking now, right? Because this person simply didn't want to pave more land, so they lied about how many employees they had, right? That was a failure of us to enforce our zoning without, and question what we're being told, probably. But on the other hand, like, it's that sort of, the negative impact of overflow cars is what we're trying to regulate, right? So that's something, again, to take into account.
One other thing I also want to say. So, all right, another pop quiz. So, I'm buying, where's the gas station the Vanna gas station located, corner what and what?
Right across the street, basically.
Yeah. So I'm buying a gas station. I'm going to reopen it as a gas station. It's permitted use, right? Right, special land use permitted. And I'm going to rebuild it. But here's the thing. I'm rebuilding the store with a giant statue of a clown on top of it. It's not going to go over the height requirements, but I'm going to have my giant clown. You guys can't say no, right? My land, I'm meeting all the requirements, dimensions. I want my clown.
No.
Why? Do you have to give me my clown?
Is it art?
No.
That's a good one. We're getting, give me a second. We're good. But we're not, yeah. This isn't the art commission. This isn't, right? But yes, it's art, and what's more, it's important to my business, how I'm gonna attract customers. You can't say no.
Yes, we can.
Why?
Well, again, I would think that there would be some
height.
a development requirement or a beautification ordinance or.
Right,
Design standards.
Okay.
right.
If you have design standards, you have reason to possibly say no to that clown,
Yeah.
right? Right, add a character, right? This is where zoning is that gray, right? This is where, why I say, anyone who studies criminal law who wants to get into planning law, I say, are you okay with gray? Well, I can, no. Are you okay with gray? Because if you're not, you shouldn't be in this business, right? But this is where, you as a planning commission shouldn't be afraid, right? Because if you have design requirements, and I have one community, I keep referencing the same one over and over, right? That, there was a Dollar Tree, and they left because they didn't want the design requirements. Well, sorry. Now, it was a family dollar. It was a Dollar General, right? Dollar General didn't want to do it. Dollar General can design some nice stuff. They don't want to, but they can. So now, if they ever get their second site plan, it's going to be Dollar Tree because they agreed to, right? Design. If you have design requirements, yes, the planning commission, you can potentially say yes or no. Put that out there.
I thought you were going to go down a signage rabbit hole.
No, we're not going to sign it.
Because we could do a session like this on signage, just on signage.
Yes.
But
we're going to be charging.
Ordinarily, well, maybe not ordinarily. My philosophy on giant clowns is usually that they're signs, and you can have a sign, but it can only be this big, right? When we put a big clown on, that's on you. In fact, the U.S. Supreme Court said we can't.
Well, this giant clown is going to be part of the roof. How about that? Be part of the roof structure. So
I've
part of my design.
I've had this discussion with developers before. Applebee's apples on the awnings, or whether the McDonald's. The swoosh thing that McDonald's used to have in their buildings, that sign. Anyway, I told you we could do signage forever.
Right.
So yeah, but by defining sort of the characteristics you want, and again, you can go much more intensive. There's all the communities can be Detroit suburbs, but there's another one that requires all the commercial buildings to be red brick. The only colors in the world that isn't painted white is in this community. It's required to be red brick, right? Bloomfield Hills requires all signs to be black and gold. Which I actually think is unconstitutional, but people go along with it because Bloomfield Hills, right? So my point is, you can establish rules like this. You don't have to, right? You can be more, you can be more sort of libertarian about it. It's like, hey, this is your property, your business. You advertise how you design how you want, as long as you stay within more of the safety rules, like how wide a parking space is, right? But so this is the level you guys are going to kind of have to decide for yourself. Right?
And it can vary from zone district to zone district too, right? What is appropriate. One might not be appropriate.
Yeah, so zoning ordinance development process, right? It's led by your planning commission because planning commission is the body tasked with taking this policy, law development off the Salem Township Board plate. Ultimately, Township Board is responsible, but Township Board has a township to run on a month-to-month basis, right? They don't necessarily have the time and capacity to be looking at a 200-page document and making sure they like every word of it. Like, that's the planning commission. Sorry, planning commissioners, that's what we're looking forward to in this next stage of the process here.
It's only 191.
Yeah, well, exactly.
No big deal.
Yeah, so, that's what the planning commission exists for. In fact, if you're writing a zoning, if you've never had zoning before, and you're writing zoning ordinance from scratch, the Zoning Enabling Act requires you to establish a planning commission for the purposes of writing zoning. Okay? So it does a little level of intensity here. There's also a formal and an informal side to developing zoning ordinance. And we're gonna lay out a schedule once we get into it. Because the end of the process is actually less intense than the master plan, right? The master plan is 4 meetings of a 63-day comment period. It's a lot. A zoning ordinance is 2 meetings. It's a public hearing by the planning commission and adoption by the board. Formally, right? That's all you need to do. Informally, we will almost certainly be having drafts or segments sent to the township board for their review and comment in a public forum, and then have them send it back. Right? Because we do not want the township board to get this 200-page document for which every word must be perfect, right? And yes, you have to adopt this. This is what the planning commission gave you. We need that input in advance. So we're going to be going back and forth on specific topics as we go. I don't know where you got 6 to 8 minutes.
It was on the slide, and I, probably should take it off. But
well, I mean, I think
it's aspirational. How about that?
We like pressure here.
Yes, exactly.
You could do it if you can work together and gain consensus, right? And I think that, I hope that the master plan process has given us this vision, right? Let's see. So we talked about how the master plan and zoning ordinance work together. Rezoning to fit the master plan, I brought that up earlier. The spot zoning thing, I brought up earlier. It is a thing, but it's not. It doesn't override everything else, because if you're just the first thing in an area to change zoning, that's fine. Legal stuff.
Wait, could you just go back one slide?
Yeah.
Talk about supporting other communities. You speak that a little bit,
Yeah, all right, so the master plan, as you know, it is required that you coordinate with other communities, which we just did, right? We did distribution, we sent it to all your neighbors. Zoning doesn't have that formal, you have to send it to all your neighbors requirement, but that doesn't mean it's not a good idea, right? And there are actually a number of communities that have adopted the exact same zoning for both sides of the road that divides their community, right? And that's something you could potentially do if you were in the city of Battle Creek or some of the other neighbors. If you wanted to, you could incorporate something like that. It's not 100% necessary, so long as you're reasonably consistent. But you will sometimes see communities where it's like, well, I can come right up to the township line, and the other side is a factory, because they put industrial at the edge of town, right?
I mean, we do have quite a few roads now that are
One side of it, yeah. Oh, I actually have a meeting coming up.
But it's okay. You just ask consumers' opinion. They'll tell you. They'll be all regional, and you'll be
That's it. Yeah, that's actually a good one. I worked with a 1,500 acre solar farm, so it was a big one. But it was half in one township and half in another. And they were like, well, we gotta follow Massachusetts rules. Well, yeah, you gotta follow 2 sets of rules. You follow in 2 townships. Since you guys consider it one,
sorry.
Too. But there are
sure you're not
you're
using
to work together on that.
But in this case, maybe.
But on a more sort of friendly basis, I have a community, I have a meeting in a couple of weeks between 2 townships which have a major, it's a state highway that divides the 2. And one of them, they zoned the entire thing commercial, and the other one is zoned the entire thing agriculture. So as you drive down the state highway, all the businesses are on one side. And we're gonna have a meeting to try to sort of reconcile that, because, if we could make it a little more even, or make it so maybe this community doesn't have 4 miles of commercial, but that's the point. If you can work on that, you can both of you adopt the same thing, so it's the same on both sides. You have to, not necessarily. And I don't know if you guys have any situations, you have that lake that you split, right?
St. Mary's?
Yeah. So we can talk about that as we get into that zoning ordinance process.
I mean, I've got a dozen situations that I can.
Right.
Okay, so we'll talk about it.
we're interested in moving forward. As we get into the zoning.
Now you make an omelet.
That's
You
right.
make an omelet,
You
Mike.
can break them.
Yeah.
The zoning ordinance, it'll be like eating an elephant, right, one bite at a time. Okay, so, legal limitations on zoning, because it's the law, because it takes property rights, because you don't have the ability to zone except if the state says you have the ability to zone, right? These things are, they put you in a box of what you are allowed to do and what you're not allowed to do. The biggest thing you're not allowed to do with your zoning is take people's property. And they don't mean that literally, they mean it in the case of this person is not allowed to do anything with their property and therefore it is worthless and you're taking that value. If you do that, that's when you lose lawsuits. And sometimes you lose lawsuits big, or get consent judgments, which is the judge ordering you to allow something that you didn't want to allow. So that's what you really want to avoid.
Can you give an example?
Yeah, so, well, I mean, the most obvious example would be if you created a zoning district that didn't actually allow anything except like trees, right? If you said, and you wouldn't do this, but if you created a zoning district called open space, woodlands preservation, and you weren't actually allowed to do anything on that property except keep the trees nice, that would probably be a thing. There's a lot more, less sort of obvious examples. There's some relatively famous court cases out there about whether you can require developments to set aside land for things like bike paths or future roads. The answer is not a hard no every time, but there are things, if your bike path requirement means they can't get a driveway out, right, then that's gonna be a problem. Driveways are actually a very big source of this kind of thing. If you say, we can only have a driveway every 150 feet for safety, which is a reasonable safety requirement, actually, when we talk to a traffic engineer, but then if you look at the lots, and it's, well, my neighbor has a driveway, my other neighbor has a driveway, so I can't have a driveway, and therefore I can't build a house, that's taken, right? Some other examples. So there's also, trying to come up with an interesting example here. Yeah.
So many of them in more of the commercial districts have to leave a watershed.
Yeah.
For drainage.
That's a good point. Yeah, where that actually could be one, because I've seen a Myers that had to build a retention pond bigger than the Myers. So it's basically next to a lake. If so, a requirement like that made it so, this is where I was trying to sort of noodle out and come up with an easy example, but if you have requirements that end up conflicting with each other, so you can't actually comply with all of them at the same time, for instance, that's a really good point about stormwater. You have a stormwater detention requirement that requires a pond that's this big, and a parking requirement that requires a parking lot that's this big, and now you don't have any room for a building, that would be a taking. In a situation like that, because you may not be able to identify in advance that might come up, that's why one of the reasons the ZBA exists. One of the criteria for granting a variance is it is impossible to meet all of these requirements at the same time, so one of them has to be, at least one of them has to be waived or reduced. Okay? So that's takings. The other big one that you're gonna run into is what's called exclusionary zoning. And that is a zoning ordinance that doesn't let you do a certain legal thing anywhere in the entire community, right? And that could obviously be as simple as, well, we just didn't include mobile home parks in our ordinance, or something like that, right? I bring that up because that's an actual case. The city of Novi was sued because they did not allow mobile home parks anywhere, and they lost, and then it's become, hey, we have to reserve space for mobile home park everywhere, right? Now, that doesn't mean that every single thing someone could possibly do has to be easy. It doesn't mean every single thing that someone could possibly do has to be a permitted use by right somewhere. It could be special use. I've even had some communities, well, your upcoming employer, right, with their mineral mining zoning district, which is to say that in order to put in a gravel mine, you must, in Clinton County, get a rezoning and then a special land use, right? But that's not exclusionary zoning because there's a process. It's just a multi-step difficult process, right?
And Clinton County has a lot of gravel pits. So they need that regulation.
And this comes up, of course, with wind and solar, when we say we'll have setbacks from certain things, you wanna make sure that there are places where it's possible, right? Doesn't mean that every lot has to be possible, just some. So that's exclusionary zoning. Due process, if someone asks for something, you have to respond and take them through a process, even if the answer ends up being no. You issue a denial, you can't just sit on it.
And I gotta say something. This goes to, you probably know this already, but in one of my communities that I'm working in, I got a request, and this goes on the list of like the weirder requests I've ever gotten. All right, so I'll just tell this story. Okay, someone called. They live in an agricultural district, right? But they have a 2.5 acre lot built out. Can you guess what they want to put on it? Starts with a C, ends with a Y. A cemetery. They want to build a private cemetery on their 2.5 acre lot. Where? I don't know. Now, this to me is kind of, now here's the thing. If you have 10 acres, sure, you got behind the barn, you know, I can understand. 2.5 acres, already built out, big house on the property. I'm like, you know, and the first question, actually, I got the call from the assessor, because the first question was, how do I split the land off? And it's like, how are you going to split the land off if you don't have access, road access? You're not, you know. And so, now I may think this is completely accurate, but I have to talk to this person. I have to give this person their due process, right? It doesn't matter if the request is, well, can I keep African elephants in my backyard, right? Or can I keep elephants, but they're Indian elephants, so their ears aren't as big, so is that okay? Like, it doesn't matter. I mean, you will get the wackiest requests. If you don't answer the call, you just violated their due process. You have, okay? It doesn't matter what you think of the request, it doesn't matter your opinion of it, right? This is why I always say, and this is why how I approach things in general is, even if I think it's completely wacky, let's give you a path, let's find something, right? In this particular case, I found out that Lara actually, the state has very, very specific rules for private cemeteries. So I directed this person to the Lara, and they have a cemetery commissioner. There's a state cemetery commissioner, just so you know, for specifically private cemeteries. And you have to set up a trust and the whole thing. I look at things every day. But I know what's the point. I called the person back, I had a respectful conversation, right? On the phone, they seemed like the type of person who want to put a cemetery in their record. I'm not going to say any more than that. But point is, this person had their due process. It's getting their due process. It was very simple. Anyway, so yes, yeah.
Were they a cult or something?
I'm not saying, I don't know.
Were they going to sleep in their coffins at night?
I was, you know, there's certain questions you don't want to ask. Certain things you just don't want to know.
I've heard a rumor that if you have a cemetery in your property, that there's no taxes anymore. Tax-free, if you have a cemetery, can't be taxed.
It can't be taxed.
That's what I've heard.
Well, that, again, I would direct you to the state cemetery commissioner. They will answer all of your questions, right? I do not have those answers, but you do have to go through the state if you want to have a private cemetery. That much I've learned.
You also have to endow a trust for in perpetuity.
Yes.
It may cost you more than taxes.
Right.
Yes.
So.
Yes, that's true, yes. Even that, and for after you die, this trust has to
Yes,
exist.
it has to exist forever.
Forever.
So the grave exists.
Right, exactly.
Yeah.
So just keep that in mind, you know. Anyway.
That comes up.
Yeah. So anyway, but yes, so anyway, that's the point to do for a lot.
Yeah, and then the last thing I want to say on this slide is sort of the state giveth and the state taketh away, right? You have, your zoning is in the box created by state law and state case law, right? And the U.S. Michigan constitutions. But it's relatively common for the state to needle with this in one way or another. One example, I just went through that whole thing on exclusionary zoning. There's an exception to that, and that's commercial scale marijuana, right? As you guys know, that you don't have to allow large grows or marijuana retailers or that kind of thing. There are, if you talk about marijuana, you guys probably have, right? You know, there are things that fly below that radar that you can't prohibit, but you can regulate. But that's one thing you can basically say, hey, I want to do a Class A grow, and here's my license from the state. Nope, can't do it here in Bedford Township, right? And that's like the only use you're allowed to just say flat out you can't do it. Flip side, telecommunications towers are protected by the state such that you can regulate them, but only within this little tiny box the state gives you. So that's one thing. There's obviously a lot of talk about mineral mining, and there's now talk about solar being taken away from locals. and I don't know, neither of those has gone through. The mineral mining one has been out there for, God, a decade and hasn't actually passed. The solar one's pretty new. The other one that's out there, was for a while short-term rentals. That never actually passed. And actually, like the state went the other way.
On the floor, wasn't it?
Yeah, that was.
Did not. So there's no, you can regulate short-term rentals. There's a little like case law about short-term rentals.
I think you said that it actually got to a vote.
It did.
Yeah,
But it hasn't passed.
it got further than it's ever gotten. Right.
Yeah.
You know.
You know, I think the clock ran out of the session.
Oh, is that what
Something
happened?
like that. Yeah, they tried to bring up a late doc and ran out of time.
Mhm.
But yeah, there's some case law around short-term rentals and whether they're commercial or residential, and frankly, from our perspective, it doesn't matter that much, and you guys are probably not a big short-term rental community anyway. But that's another thing the state has sort of debated. So something to keep an eye on, because I brought this telecommunications one because one of the things that has in it is a shot clock, which is to say after you get an application, if you haven't approved it in, I think it's 90 days, it's automatically approved. And we've had communities that weren't aware of that, and, oh yeah, planning commission meeting, you know, and, oh, no, automatically approved, here's our 200-foot tower, sorry, you know, so, that one is less of a thing than it used to be, because cell towers, we're out of the era of 200-foot towers, and we're into the era of micro cells, and those were supposed to work, so. But it's an example of the kind of thing that can go into state law that creates a totally different situation when you have linear land use. So those are your legal things. Kevin?
Which, so if the state does perchance make a law about zoning of solar, wind, does that supersede township?
Yeah.
Or does
It will.
township supersede that?
No, it would supersede township. If they make a law that says this supersedes the township, which they're allowed to do, right?
However, the provisions, however, it might not affect all the provisions of your solar ordinance. Some of them might still be valid.
Yeah, it really depends what the state says.
Yeah.
For instance, to go back to the telecommunications thing, the sort of carve out the state has for that does not say, it's not the Right to Cell Towers Act, which I didn't mention that one, that's another one, Right Farm Act, right? But the Right to Cell, it's not the Right to Cell Towers Act, it's you can't make me get a special use permit if I'm just changing the antennas and not changing the height of the actual tower act, right? So it might be, any sort of solar action might be more along the lines of, you know, you could still require a special use permit and say yes or no, but you can't prohibit them entirely in your agricultural district or something like that. It's just like, if the bill's even being introduced, it was just in the last couple of days. So that specific one is so brand new that we don't really know where it's at. Yeah, and when these things go through Lansing, we never really know where they're gonna come out, right? So I don't know what that one's gonna look like. But it is worth noting that there is a bill in the legislature that would reduce or eliminate local control on solar. There is not one on wind. There's not a wind bill in the legislature as of right now, just a solar bill. But that's kind of what this is aside. We've already talked about some of these powers and stuff like that. We talked about township board influence and some of the gray areas there. We talked about planning commission functions and responsibility. We talked about ZBA decisions. We should probably talk about the last thing on here, which is ZBA decisions are final except for one.
Right.
So the ZBA is your Supreme Court. Right? The ZBA says it's final.
But they can still take it to local court.
They take it to court.
Yeah.
Within your township, the
It's fine.
ZBA.
It can't go to,
The township board can't. go
Right,
right.
yeah, right.
That's the big one.
Yeah.
Should we talk a little bit, about, variance criteria? On the slide, or is there another slide we should do?
To see, we can talk a little bit about it. I don't think
You wanna save it for the end, Raphael? We'll just do
yeah.
we'll do one example of the ZBA and then.
yeah, I think that makes sense.
Okay, we can do that. Yeah, I mean, we've talked about all this stuff. All right, difficult public hearings, which is our last topic in the slideshow. This is something you obviously guys have experienced with. I know.
We're pros.
You guys have done this, and I'm sure that you've got things. I see your clock over here, right? Your 3-minute clock. About addressing things to the chair. I don't know if
You've got a whole set of rules.
Oh,
to
yeah.
protect us.
Yes,
Yeah.
exactly. Do you guys put them on the agenda?
We don't put them on the agenda, but they are available.
They're out now.
Okay, yeah, cool. So they're right available. That's good. That's definitely a best practice.
Mike has done a really good job, I'm just gonna say.
Awesome. Strong chair? is
Yeah,
always good.
strong chair, yeah.
Mine.
It's a hard job. Somebody's got to do it.
The good thing is checks don't bounce either.
Behind every great man.
Right, I wouldn't be anything without my trusty sidekick partner.
We should on this slide talk a little about the Open Meetings Act. We got into the, if you have a quorum at the bar, or sending emails and that kind of thing, as Open Meetings Act stuff.
I really want to know after how many drinks is it the vote doesn't count. I just find, that we should ask, Les Beth that question.
Yeah. Anyway.
Sorry.
So, the big important thing is all your deliberations on substance and things you're gonna vote on have to be in public, right? And take it down on rates and that kind of thing. Phil McKenna, right, who founded our firm, likes to tell a story of before the Open Meetings Act. He used to work with a planning commission that would take public comment, and then they would adjourn to a back room where they would play euchre and drink beer until all the public got bored and left, and then they would come out and announce the decision. Obviously, you cannot do that. Yes, this is why the Open Meetings Act was adopted. It was stuff like that. See, obviously, you cannot do that, but make sure you have your deliberations in person. You probably do have to dial up and dial back the formality of a meeting, just depending on how busy and controversial it is. You don't have to be kind of hardcore Robert's rules, but talk to the chair, talk one at a time, let the chair call on people. Have a clear opening and closing of public comment or a formal public hearing, right? With a motion to open it and a motion to close it. And when it's closed, nobody can speak, except maybe you can invite the applicant back to speak or something. But just, you don't let it be a conversation back and forth, right? But flip side of that, important to let everyone speak, right? Which is one of these, but it's not that one. It is important to let everyone speak. Give everyone their 3 minutes, right? Don't cut them off. Don't speak back to them. And one aspect of that, sometimes people will come up to the podium and they'll just ask a bunch of questions, and they'll kind of look at you like, answer these questions, right? As tempting as it is, you shouldn't answer questions in that moment. It's best practice there is for the chair or the secretary or somebody to write down the questions, and when the public comment is over, to sit it for the chair to say, we've heard the following questions, and I want to run through them, and I want to defer them to the zoning administrator, or the planner, or the attorney, or the applicant, or someone who can answer this question, right? And it's the best practice is to do that clearly and formally, and then people hear, okay, that was my question, and that was the answer. And I didn't get the answer immediately, but I got it eventually, and I got it in an organized fashion, not a shouting back and forth, right?
And sorry. But I also will say that, yes, we you allow everyone their time, but as Mike knows, you also, don't allow disorderly conduct, right? You're right, that the chair's job is to put their foot down when it's becoming a disruptive, it's becoming a hindrance to the process and not a help, right? I think that's kind of the threshold,
yeah.
Right?
I also have found that if you do the writing down of the questions and bringing them back out, you diffuse the power of bad faith questions, right? Are you here to ruin our township? Are you here to ruin our township? Oh, you have a question? It's, are you here to ruin our township? Right? Now it's lost power. It's now it's the emotion's been taken out of it, and it's just not so stuff like that. But just keep things formal, organized, and make decisions based on information and reality, and not emotions necessarily. Now, the public comment very frequently does bring up important things that may not have otherwise come out. That is, it's not, public comment is not like a waste of your time or an annoyance. It's very, very important. But it is important to sort of distinguish out, oh, that's a really good point. From up on that hill, this is going to be very, very visible, right? Or all that water is going to drain towards this guy's basement. And okay, yeah, that's important. Now we know that. All right, so now that you've taken all that public comment, now it's decision-making time, right? You said you're talking one at a time, addressing comments to the chair, deliberating. there's a couple of options, kind of talked about this, oh yeah, this is what I'm talking about. Couple of options with kind of how to organize your discussion. You can have a sort of generalized discussion, you can go down the line one at a time, what does everybody think? But another option is to actually have someone make a motion and say, I move to approve this, or I move to deny this. And then you get a second, and now what happens next is not a vote, it's a discussion on that motion, right? Now you're focused on the motion. Both the motion can later be withdrawn, it can be voted down, it can be voted in favor of.
Be amended.
You can amend it, but now you're focused. This is what we're talking about. We're talking about this motion. Another thing I've seen, and this is going to kind of the opposite side because it's more on a more informal basis, but we had a zoning ordinance in a big, complicated community. The zoning ordinance process took 3 years. You guys won't take 3 years. We had hundreds of people in Zoom meetings at the depths of the pandemic, right? But, it was a long and arduous process. And when we got to the end of it, there were, we could count them, there were 9 things that people didn't agree on. And what the city commission in that case said was, we're gonna have straw poll votes on each of these 9 items. And whichever the majority is on each of the 9 items, that's what the rule in the zoning ordinance is gonna be. And after we take those straw polls, then we're gonna have a final vote on adoption, and it's gonna be unanimous. We all agree in advance, whether we win or lose these votes leading up, we're all gonna vote yes at the end. And they made that deliberation in public, so it wasn't like a collusive thing. It was like, public hearing, folks, this is what we're gonna do. We have 9 votes, and we're all gonna respect the outcome of those votes, and at the end, we're gonna vote to adopt this, because the other 99% of this ordinance, we all agree on. So eventually, you may get to a point where you, especially when you're talking about a zoning ordinance, or a big zoning amendment, or something like your solar ordinance, where you get to that point, you have to say, how are we going to stop talking and build consensus here, right? Last thing on here is the minutes. Obviously, it's a really important job for the person taking those, and it's very important that those be kept on file, that they be approved with the following meeting, that they be corrected if they need to be corrected. Particularly if you're doing something like approving a special use with a bunch of conditions, because special use conditions may run with the use for as long as it goes on. They might still be 50 years from now. They might still be prohibited from operating after dusk, or something like that, right? You want to make sure that there's a good record or something like that. We've talked about the potential for lawsuits, and what leads to lawsuits and what leads to losing lawsuits. I think Raphael made a really good point earlier about procedure. It's easier to lose on procedure than anything else. We have a number of townships in Ingham County, and Ingham County does not have a planning commission. We have an attorney there that insists on sending everything to the county, all the zoning amendments to the county for comment anyway, just in case anyone ever challenges on the fact that they were sent to the county. Here in Calhoun County, you have a planning commission, so when we get to the zoning ordinance process, we are going to submit for their formal feedback, which you do have to do when there is one. But the point is, even to the point of overkill, making sure you're doing the process right is very important. More common is public hearing notices, right? They have to be in the newspaper and it's sent out 15 days in advance. If they're not, it's not on the agenda, not until next month, right? That's important. It's also important to remember what needs a public hearing, right? Special uses need a public hearing, rezonings need a public hearing, variances need a public hearing, site plans generally do not. Yes?
If you have a special use application that's potentially really contentious, like solar, would it be appropriate, or could you have the attorney do the meeting minutes and the fact finding for you?
Meeting minutes, yes. Yes, the other thing that an attorney or someone like us can do that's generally helpful is write out motions. And in those cases, it's best to say, this is your approval motion, this is your denial motion, this is your tabling motion. So it's not, I'm telling you to do this, it's, if you choose one of these 3 options, here's what you should say. And that's why a lot of communities use us to do a report on zoning, not on things that the zoning administrator will sign off on, but things going to the planning commission, giving you the detailed breakdown of how this meets with zoning ordinance, and then give you a recommendation of how to do the motion. So those things you can use a professional for. And yeah, if you are in a difficult, controversial situation, it is very important to have an attorney on hand and have them appraise the situation and that kind of thing. Though we like to think we're helpful in those situations too. So,
Yeah, it's very, I find it just very helpful for the planner and the attorney to tag team a lot of, those things. Because sometimes, we actually really do complement each other, with our expertise, so it's never a bad idea, if there's a instinct that, will help will be helpful, we're not gonna be territorial with the attorney, like, it's just not how it is, we work with attorneys all the time.
and attorneys tend to be very good at things like procedure and paperwork.
Yes.
Right? That's what they do.
Yeah.
The first two up here, I'll talk about before we move on, is basically they can be summed up as don't be arbitrary, don't be random, right? Make decisions based on facts, write those facts down, put them in your motion. They can be facts that come up in a public hearing, facts brought to your attention by professionals, facts that the applicant came up with, right? But don't be arbitrary. Always make sure that things are based on your master plan, based on the surrounding land uses. I don't go back to this duplex thing that I was talking about last night with our community. There were a bunch of people at the hearing and they didn't want any duplexes. Well, there were duplexes across the street. So saying you can't have duplexes in this neighborhood was not the right answer because they're right there, right? The whole disagreement on street frontage, that's based on facts. That was based on interpretation of the ordinance, so it's a little bit different, but at least it's an objective fact. You've got 80 feet of frontage, it says 100. Right? It's not, these people think that the duplex across the street, the people that live there don't cut the grass. Well, that's not a reason to prohibit it, right? So that's the kind of thing.
And also, just going back to process also, and I'll give an example. So, but I'm thinking there was a zoning text amendment that in the community that was brought forward. It was voted unanimously to the city council in this case, and the city council voted it down because one or another business owner didn't like it because it was on north of a certain block, not south, and they were not going to benefit, right? Personally, I think that's a political calculation, right? But when I approached mayor about this, they said, oh, but because one person said, and then then what am I doing with the other business owners? Well, that's not your only concern, right? It is the temporal concerns of the business owners, right? Again, going back to deference, ordinance, master plan, right? Looking at the entirety of the picture, right, based on this. And I'm going to say one more thing about this. When the applicant called me and said, what are my options? Due process, I was obligated to say is, you have every right to call your attorney, and you have every right to sue the Superior Court. I legally had to tell them that, right? So this is just, again, something to be mindful of when the board making these decisions, right? Political expedience is usually not the best way to go. And this is not a comment on this community, this is just a comment on general things that I've seen out there, so.
One other thing on this slide, and that is regarding the professional advice thing. So us and attorneys and frankly your zoning administrator, right? You do not have to follow that advice. However, now that it's in writing, if there is some sort of lawsuit, it will get thrown in somebody's face at some point. Right? We tend to, when things go really bad, we tend to get deposed, and anything we wrote down gets deposed. Right. I had a 2-hour discussion with a lawyer under oath about what the word road meant. So these things can get weird.
What was the one about? What was the hour and a half about the $100 fine? About the.
Oh yeah, I have had one property owner spend tens of thousands of dollars fighting a $150 blight infraction fine. So that was fun.
There's a lot of people out there like that.
Yeah.
They will do that just for the principal.
Yeah.
I don't care how much they spend.
It was interesting. Yeah. But yes, you're absolutely right. Some people would just, hey, it's not bothering me.
Yeah.
Well, anyway. Some more suggestions. We talked about this. Meetings like this are important. This is a good topic for one, but you also can use this, to develop policy on big topics. Solar, you already did that one. or some aspects of your master, or certain aspects of your zoning ordinance, or things like that, bringing everybody together, doing the thing you did at the beginning of this meeting, where you guys all took roll and said if you had a quorum or not, right, that's, now we have a formal public meeting, we're in compliance with everything, but you guys can talk to each other. So, that can be really good. We talked about the board liaison with planning commission, that relationship goes the other way too, that liaison should be report to planning commission, stuff to the board. And yes, you know, you guys are keeping records, so if you weren't at the meeting, read the minutes, you got the record. We talked about liaison communication, materials 1 week in advance or more. Those are important, you guys. That's obviously very important for you guys. You guys need to know. You guys need stuff in advance so you can read it. Right?
They're
Planning
much
commission-
better about that now.
Greg, I whip on us, right? Yes.
Oh, I just had a comment that's so important about the preparatory work and reviewing your ordinances and everything before whatever meeting, whether it's board, PC, ZBA, because I have had the opportunity to sit in meetings and be a part of them when a member has clearly not reviewed the information, and you talk about opening yourself up and being deposed when 1 or 2 members of that board is not educated to the ordinances and is using the meeting time to educate themselves. It can go really bad. So there is the opportunity, I think, before those meetings to educate, ask questions, and get answers ahead of time so everybody's making a educated, informed decision and not open with the public educating themselves.
And if I could add to that, don't be afraid, speaking to the staff, don't be afraid to say, you're not gonna make the next meeting. Your application's not complete. If you're missing critical, and I've been in this position personally where you wanna be nice, you wanna be accommodating, you want everyone, you want to give the time. But if you got, 5 applications, right, and you're drinking from a fire hose, and this person's like, oh, but I really need to get this because my lease is expiring, or my option's expiring, and it's like, it's like, now you might want to create some kind of, remedy, administrative remedy around like special meetings, that kind of thing. But at the end of the day, we have a job to do, right, as staff.
Yeah.
And if they're not, right, if they're not complete, they may desperately want this, and they may desperately need it, but it's like, no, I'm sorry, you're not ready. You submitted a site plan that was drawn on graph paper, true story, right? All right, it's not gonna work. This is what we need, you'll get it for the next meeting.
Right.
Don't be afraid to say no, right? That's another part of the due process.
Yeah.
Holding people to account. If they don't have what they need to provide, to say, I'm sorry, right? We'll work with you, but you need more than this, right? And you can even phrase it, I find you can even phrase it like, if I put you up there with this, you're gonna fail.
Right.
You will be laughed out of the room. Sometimes I will say that. I mean, if you don't want to say a hard no, say, listen, I want to set you up for success. This is not going to be successful.
Right.
And oftentimes I find like 8 times out of 10, and 9 times, that's almost enough for them to, okay, you're right. You're right. We want to do this the right way. You want to be successful, right? So that also is the best practice.
And my other thought on what I was saying is that asking questions ahead of time doesn't constitute as a quorum. So
like an application?
Well, anything before a board meeting, a ZBA, a PC meeting.
Right.
Sending those questions to your chair and getting that educated answer ahead of time.
And then they can email us if they don't put your right.
Your chair and your zoning administrator, as long as it's a 1-to-1 communication.
Yeah. Don't reply.
Right. I still say BCC is your friend.
Right.
BCC is a group, they can't reply all.
Yeah.
So whoever gets the email is unable to reply all because it's only showing your name.
Yeah. You don't, it's the substantive email with everybody on it that's the problem. It's like, hey, this is just quick to the zoning administrator, be in chair, or whatever, it's to one of us, or something like that, that's fine.
But even the replies of, council replies of "I'll be there" can get pretty annoying.
It's so annoying.
I'll be there. I'll be there.
That's not Open Meetings Act violation.
No, it's not. It's just annoying.
It should be, right?
Yeah.
One thing that's on this slide that we haven't talked about yet, and that is the planning commission at the end of every year should be producing a report of what they did that year. It could be as simple as these are the meetings we held, this is the things we did at each meeting, and that goes to the township board. That is actually in state law that you're supposed to do that, though I've never seen anyone get sort of challenged on not doing it, and a lot of communities are relaxed about it, but you should be doing it.
We do it here.
Yeah, excellent. Good.
You know, that was a question I was gonna ask you, if you don't mind. I was look back in the master plan portion of the presentation. Knowing that ours is going in and went through the full process and is getting approved. Would it be advantageous to quantify the getting approved? Would it be advantageous to quantify the decisions made by the PC and the board moving forward and have that knowledge of these ordinances, these articles, or this issue repeated itself? So obviously those need to be addressed in the next master plan
For sure.
revision.
Yep.
I've never had the opportunity to start at the same time when the
Brand new.
yeah, with the planning or the master plan being brand new.
I think that's
So it'd be really,
yeah, it's absolutely a good idea. We will, in some cases, we do it here, in a zoning ordinance, put a little thing at the beginning that is actually for note taking on issues by the zoning administrator. And certainly we could do that in a master plan too. I've never done it in a master plan, but we could certainly have like, hey, this is the notes page for people to write down, there's an issue here that we haven't addressed, and we need to, next time this comes up. And the nice thing about it is if you do have a slow period for planning commission where not a lot of people come into the planning commission for approvals, then you can get to that list and start saying, all right, you guys, I've some communities where the agenda at the bottom, it says, potential items for upcoming discussion. And then there's a list of stuff that the planning commission maybe doesn't have time for right now, but is gonna get to, and then it becomes public, right? Like to the public, we're gonna talk about this stuff eventually. It's just that tonight's meeting was 3 hours even without it. So
Yeah.
It won't happen yet, so.
okay, thank you.
Yep. Having your documents available, websites are great for that. Having maps available is particularly important, for the quick reference. Some communities blow them up big and put them on the wall, and then they can be referenced easily.
You guys have the future land use map, right? You guys have. So
Yeah, I think we've done something like that.
Yeah, I mean, I'm saying you have the big.
Oh, yeah.
The big one.
Yeah. I thought you were being funny.
No, I was.
How can you forget that we have that?
Yeah. There was that thing.
Yes, we still have the big one.
Okay, good.
And you also have AV technology you can use for that.
Right.
So obviously we've been back and forth with questions the whole time, but it is right at 7 o'clock, so, are there any final questions?
Why don't we, if we can, Raphael, if you wanna just touch on, I guess, the requirements, for variances for the ZBA, just kinda,
Okay.
I mean, they're just for the sake of, they have 2 new members here.
All right,
tonight,
sure.
So,
Absolutely. So for
I
variance.
guess specifically how important it is to, you have to, show that you have cause.
Oh, right.
Not just, because I say so.
Right, yeah. So variances, I mean, and we get a whole session just on variances, but quickly, well, 2 things come to mind particularly. One is, I don't believe the draft that we provide you has a use variance option, correct?
Yeah, it is now very uncommon to give use variances. A use variance is what it sounds like. This use is not permitted in this zoning district, but I want to do it. I'm going to go to the ZBA, and the ZBA is going to let me do it. Under state law, you are allowed to do that. Most communities in their zoning ordinances say you can't. And the reason for that is, for me, it's twofold. Sorry to go down this.
No, this is what I wanted to do.
We should talk about this.
No, what you did.
The reason for me is twofold. One, there are other opportunities to get the use that you want on a piece of land, most notably a rezoning, right? And if someone wants to do something on a piece of land, and they ask for the zoning district where that's allowed, and you guys say no because it's not consistent with your master plan, that's it, that's the answer.
Or
if they want to do that, they need to find the appropriate place in the township for it.
Or a text amendment, that can sometimes.
Yes, yeah, that's true. They could also petition to add their use as a permitted use in the district.
Right.
That is another option. And so, but the point is, there are options. You also have conditional rezoning, which we haven't talked about, which is where an applicant will say, I want to rezone to this zoning district, but I will voluntarily give up rights that I would have in that district if you say yes. So an example of that might be, I really want to do warehousing, and I need industrial zoning for that, but I have no interest in manufacturing. And you guys are worried that I'm going to be loud and smelly and et cetera with my manufacturing, because in an industrial district, once you put me in that district, I could do manufacturing. I will say, no, I voluntarily will not do manufacturing. I'll put that in writing and I'll sign it. And it'll be noted on the zoning map that I have a conditional rezoning and I don't have the full rights of industrial. That was a huge rabbit hole, but the point is, there's several different options to get people the use they want without a use variance. A use variance, if you do it that way, is permanent, because variances run with the land. And this is, I think, the real kicker, it is very hard to actually meet the criteria for a use variance, which is that none of the uses permitted in the district are possible on your property, basically. Basically, you have to say, there's a taking here, because none of the uses you would allow me to do are actually possible, and I have to do this other use you would not allow me to do. I don't know that if you do your zoning ordinance right, nobody should ever meet that bar. So those are the reasons that I don't think use variances are necessary. And the ordinance draft says you're not allowed to.
And it's very hard also to prove, and this gets to Mike was talking about, the idea of hardship is something we should get into here, right? When we're talking about, so I'll just put this, to the RTVM, I feel pretty good a lot tonight, but what's hardship? In terms of the variance, in terms of a variance request, what is a hardship? Well, I'll give you an example. Well, so, I was, I had a mining pit, on this land, and it's zoned, and it's just not, big enough now for me to have my, my 5-acre ranch, right? And so I need a dimensional variance, right? Because I just need more land to do it. That's a hardship, right? That count as a hardship?
No.
Why not? It's hard for me.
They created it.
They created it, right? Cannot be self-this. There's always a line that says it was not self-created by the applicant, right? Right? It has to do with the land as it sits, right? And if it was something that, the applicant had done, if it was 10 years before, it's not going to meet the criteria, right? So now getting to the use question, there's something I like to call the arbitrary and capricious highway, okay? The arbitrary capricious highway is when your heart starts hitting down and you can't really find a good reason why you did something. And that's what can happen. That's never what can happen with use variances, because because you're saying well, there's some circumstances here that may or not have worked, so we're going to give this use variance. How do you quantify that, right? How do you demonstrate that on this parcel? Plus, yes, then you're essentially spot zoning, really, in many ways. So, dimensional variance. What's an example of a dimensional variance? But that's what we're talking about here.
Setback requirements.
Yep.
Setback requirements.
That's the most common one.
Right.
That's what's common.
Right. What about frontage requirements?
Sure.
That happens. That right. I'm going to Clinton County. Learn all about frontage requirements. There's a lot of frontage requirements about the other. But so really we're talking about something that is unique about the land, that is very specific, right? That was not self-created, and that isn't just about and this. Christopher chiming on this, because the question of economic hardship also comes in, and it is there, but it can't be the sole reason. This is the thing, right? There's a question that says, there's two questions usually that are asked. One is this something that is happening, you're seeing enough of, that would really just require an amendment to the zoning ordinance? Should that be the route we go? Or is this so specific to this parcel land it has to be addressed this way, right? The threshold is still very high for variances, right? Because you are making an exception to the rule. You're making an exception to the zoning, right? So that's why the onus is really on, the applicant to prove, essentially, that there is hardship that is associated with the land in itself. Whether it's an irregularly shaped lot that they have no control over, they just bought it that way, or that can count. Again, there's some circumstances, whether it's certain parts of the land are simply just not buildable, whether it might be it's part of a sort of floodplain, right, and the setbacks aren't gonna work, right? Those are examples of the hardship has, it's unique to the property itself, right? Right? Because I, dumped a bunch of stuff years ago, and now, I can't use this part of my land, and I want to, more, I want to be able to build over here because I can't build my house. That ain't it, right?
Ours is usually like someone wanting an accessory building in a very specific area, but then they don't want to pay to have the trees cut down, so they consider that a hardship, or try to get variance.
Or move the driveway, or extend the driveway because cost of what it costs cement and the trees, septic system is in the way.
So stuff like that, set aspects of a piece of property, which can be mandated.
Yes.
If they're not made by the person who's requesting, right?
Right.
But things like septic systems, because those are very hard or impossible to move,
Right.
and they're governed by county regulations that you don't have any control over, those are actually very frequently a good reason to grant a variance.
Yeah.
Okay.
If the previous owner did something,
Yeah.
right, and the current owner, that is not a self-created.
And
Right.
the trees one is interesting because you do have a sort of public interest in preserving trees, right? And if they're big, old growth trees, it's gonna take a couple hundred years to replace them. You could say, yeah, that's a set feature of the site or something like that. So that's kind of, that has become a gray area, but it's possible.
Question though, tell me more about what the tree issue is, because, that could also potentially be a planning commission if it's a landscaping thing.
A lot of it
Yes.
is
Yeah.
agricultural zoning where they can put the accessory building in a different area, but they don't want to put it in a different area. They would meet all of the requirements for the setbacks, but they want it right here, and that would require them to cut down 2 trees, and they don't want to spend $4,000 to do it.
And that's where you have to use kind of your discretion as a ZBA, because the question is, do they just not want to, or is it that they can't, right? And definition of can't comes in here. And if it's like, I don't want to pay to cut down these trees, or this is an old growth tree that will take 200 years, and it's not one, it's 10, it's an old growth, or backyard solar panel, where it's like, it's not just where it is, it's kind of catch the sun, right, that kind of thing. Driveways, I think can be, but are not necessarily sort of inherent, where it's like, well, I'd have to build a driveway that goes another 200 yards. Well, maybe that's, well, just put it this way. As a driveway that's going another 200 yards, that's expensive, but that doesn't mean you can't. It's a driveway that has to go 200 yards and the hill is like that. Oh, well, we got this hill, now it's different, because now we have a major impediment that you had nothing to do with, it's the topography. Or I had somebody that wanted to split a 10-acre lot into two parcels. And it's a minimum 5 acres in this district. And I went, all right, split it right down the middle, 5 and 5. What's the problem? There's a county drain running across it. The county won't let me build a driveway across their drain. So the property line has to be the county drain, or creating an island of property I can't get to, right? It's things of that nature that become, okay, that's your hardship, right? I think that in a community like this, accessory structures, being a sort of quasi-rural, suburban-ish community, accessory structures are gonna be a big thing. That's how we have to understand. If you guys, right, people want their big pole barns and all that. But to Raphael's point, asking yourself the question of, should this be a change to the zoning ordinance generally, rather than giving variance after variance after variance, right, is important. And the ZBA can make motions to recommend the planning commission explore amendments, right?
If you're seeing, so think about that. So if you're seeing a pattern of that, then that was a good reason to start exploring a possibility of the text amendment, right? To address that issue, right? So you're not just creating precedent after precedent over there.
Some years ago, I can't even remember when, it was a long time ago, there was someone who wanted to have this. But anyway, can we as a board or a commission insist on a berm of a certain distance or a certain height or trees? Because I remember, in fact, Mark Hires was the chairperson at that time. And there was something to do with the amount of trees.
The landscaping.
That they had to put in.
So that would be specific to the design requirements for specific use
Or they could be general, they
Or,
could be.
or the general.
Or district
Every
requirements.
time a commercial district is into a residential district, you must do this.
Yeah.
If the question is, can you require above and beyond that, the answer is yes, if it's a special use,
Okay.
right? That could be a criteria, that could be part of your conditions of being a special use, where it's, okay, so another example, I had, in more urban community, so it's a major road, and there's a block in the minor road, right? It's not a rural community where you have lots of space, it's pretty compact. And the major road has businesses on it, it's zoned commercial, minor road is zoned residential, and has houses on it. And an applicant came in, they wanted to put in a drive-through restaurant. And, there were landscaping standards of what you do between commercial and residential, right? But in that case, the planning commission increased those landscape standards. They said the trees gotta be bigger, there gotta be more of them when we put in a fence,
That's what
because
happened here.
you're gonna have headlights facing these people's houses over and over again. And that's not just commercial generally, that's specific to the fact that you're putting in a drive-through.
Right.
And thus you can tie it to special use. Now, if it was no drive-through, it's just a restaurant, and it was permitted by right, you wouldn't be able to do that, because a restaurant is allowed as long as they meet the rules as listed, you don't get to add more rules. Make sense?
Okay.
That's a big difference between a permitted use by right and a special use. Any other questions? Cool. Well, in that case, I will see some of you guys on September 26th. The last one over here.
And you'll never see us again?
Yeah, I'm always happy.
Come to, you guys,
I am really good.
if you're interested in this stuff and you want to learn more about it, I can recommend the Citizen Planner Program, which is a joint program with Michigan State Extension and the Michigan Association of Planning. I bring that up as you guys talk about saying goodbye to Raphael, because those are frequently held at the Michigan Association of Planning Conference, where you can run into all sorts of people like us. So,
And that's the MSU extension?
Yeah.
yes. MSU Extension, there's also they have a really nice website with all sorts of resources, as well as having a certificate program that you can do classes. Ways to get full classes. Cool.
All right.
Well, before we continue with the, meeting requirements, to end, if you guys are gonna cut out, we want to thank Raphael.
Wow, thank you.
Yes.
It's been very helpful, we appreciate it.
Thank you, guys. Thank you, guys.
That's
It's been a pleasure.
That's good, that's good to hear on behalf of the company.
Yeah, my checks don't bounce either, which is great.
Thank you, gentlemen.
Thank
you so much, guys.
I'll see you in a couple weeks.
Thanks, Chris.
Next on the agenda will be public comment. We'll open that public comment at 7:16. Is there any public comment from any members over there? Doesn't look like it, so we'll close it at 7:16. Yep. Next on the agenda will be board comments. Does anybody from the planning commission, Stacy, you have anything you'd like to add?
Not at the moment.
Kevin? Barb?
Nope.
Shirley? Claudia?
Very informative. I appreciate the opportunity to learn.
Oh, yeah, me too.
I would just like to take a minute to thank our supervisor, Jones, behind us over there. She worked very hard all week long on getting us straightened out with the legal requirements to having us all here, and getting the postings done for us, and making sure that we were above board on that. That was a great help to me. She put in a lot of time. There were several emails at 10 o'clock at night. So, I just want to thank her for that, as far as that goes.
Oh, you're welcome, thank you, and the clerk's office was.
Yes, the clerk's
they're
office
always
also,
very helpful.
yes, they did, yes, they were. Karen, do you want to let your members have an opportunity to say anything? You don't have to.
Absolutely. Claudia, do you have anything like that? No, not at this
I would just echo Claudia's comments. I appreciate this, because it's an opportunity to learn.
Absolutely. And I would just like to declare that too, I really appreciate the time that was taken and for this training, I know that I need it,
We all do, no matter how long we've been here.
yeah, well, yeah, thank you very much.
And I think it's great, just like it says here on slide 32, an annual joint, meeting of the board. I really like that idea, and I've been involved in the township for years, and there's never been such a thing. Never been such a thing.
I think it's a good idea.
Oh, I do
agree
too.
with Barb.
Yeah.
Tony, any comments from the board members?
I agree, it was very educational for me, very educational. So I appreciate that. I did want to mention too, because Karen's been trying to find, and we posted, we have one more ZBA opening. So, and I've been searching my brain to try to think of who might be good, to solicit to be on that committee. But if you have any ideas, let me know. We really would like to get a fifth, good person on there to work with you all, so.
Excellent training, thanks for inviting us. And then the other thing, if you could have the minutes reflect that Treasurer Miller is present, which makes us a quorum, yeah.
Was this recorded? Cause I could really re-listen to it. I know, right? Like 12 times.
We should be able to capture it on our cameras in here.
Okay.
It just takes a few days to get that, because we have to cut it. But then it will be posted on the planning commission site. I don't know if we'll post it on the other board and ZBA, but it'll be on one of the sites, the video. We'll let you know.
Meetings, they're broken down by board, and then they add the videos along with the agenda.
Yes, we'll work on getting the video out there.
Yeah, if you go to the website and then go to meetings, and then there'll be a drop down for the board, the ZBA, the planning commission. Yeah.
This was awesome.
Karen, anything?
I just love it. I eat it up. I can do this all over again, like you're saying. And it's so good. Yeah, exactly.
I am glad, and I will pitch this again too, is the MSU extension. There are wonderful resources there related to planning and zoning. So, just in your spare time, if you're a geek like me, wants to look at that stuff, it's really very good. Just like the MTA with all of their webinars on any topic you want to learn about, it's there. And we have the package, so you can do it for nothing. And you can get credit.
All right, is there any other comments?
Can I just do one more?
Yes, you may.
Terry and Tim, I will have you set up with the MTA next week, and you'll start getting emails. It'll send you a first welcome email, and then you have to jump in and change your password. Okay.
All right, that being said,
One more.
Oh, I'm sorry.
For the planning commission, we did have that at our, was that July meeting, that we needed to get our emails reset because we're not getting
I've
in.
got all the information to give you that we can do.
Wonderful, thank you. Sure.
Oh, Mike.
You're welcome. All right, and with that, I'll move to, close the meeting.
There's one more.
Oh, I'm so sorry.
I'm sorry, do you want the ordinances right now to hand out to your folks?
No.
Okay.
Don't overwhelm.
Okay.
All right, with that, I'll move to end the meeting at 7:22. Our next regularly scheduled planning commission meeting is September 26th at 6:30. And we adjourn the meeting at 7:22.
Yes, look.
Okay, thank you.
Nice to meet you all of you. Hope to see you again sometime. Okay.
That was the first.
Thank you for that.
I had an email that I've never even made it.
She is.
Stacy?
We gotta see what I brought.
Oh, yeah.
What is that?
That?
Oh, that's good. I happened to see it somewhere and I laughed and I slept to death. It's so funny.
I said they were doing,
Some time ago.
You know who else has crazy beat owls, but a lot of them are really.
well, that might have been what it was.
But I love them. Michael Marion.
Oh, really?
Yeah.
Where?
I love that.
Yeah, and he said, well, I'm
I
almost bought two. I only had two and I bought that one and it had to be over. I don't know. I know she has kids, right? She has the best workshop.
Well, I'm so glad.
Yeah, I need to buy more. Yeah.
But here's the thing. Right, I was so.
Really? The dog?
Oh, because, let's do a Monday, Mark.
Put me on the list for one of the top ones. Well, me and Shirley, yeah. Really?
I went to,
Yeah. That's such a good sport.
We just restocked it.
I've opened
Okay.
the private hallway. I mean,
A lot of our feeders, so it's just continue to restock. While we wait on
and there's so many.
and then we do it takes
And I apologize.
I gotta stop thinking like that.
I don't know how more than.
I was like,
When they know it, I'm telling you.
Okay, guys.
You're pulling the paper.
You can sing a song you want, but we didn't have
Oh, yeah. When we get ready, when we get ready to do this.
I got a back there.
Oh, okay.
No, because we had elections. And so, we don't have enough.
We just start. We cannot hold this. If we could learn to do
Yeah. One day at a time.
Well, when I was working around the family, you guys are all schedule and then we can all. And I'm pretty open, I have school, but, yeah, that's kind of what I think, that's what I need, I'll send out some emails to everybody who's feeling it. Get something scheduled for October, even if it's get together and, well, that and set up the next meeting, and plus at least we've done what we were supposed to do for the year. I don't want to have it every day. Well, it's really good meeting you guys. You too.
Okay.
Oh, what you got?
Or you just take a carry on. They're all on the table.
Okay.
And then Chris is part of the safety team in charge and they're doing that report as well. Well, I started going there, I do Bible studies, and I was meeting a lot of them there.
Bye, guys. Okay, bye, Terry. Right.
I don't know where it is.
I'll let the church.
Whatever you
Good
want.
job.
I know. Ask me what I'm like, I'm good. Like, did you get
Good. Don't sit next to you anymore, so.
Well,
Where?
this was kind of a special.
This was, yeah, it was.
Do you know that I'm actually related to
Oh, yeah, oh, you have a meeting, okay.
Yeah. Is this what you did?
Yeah, tomorrow.
Mr. Baby,
We know, yeah, and I didn't even think about that. By myself.
Oh, did you know that? I didn't realize.
Yes.
She thinks she left her keys in the fire.
Okay, all right. Like in the fridge, I love.
Like what?
I mean.
Oh,
I am that
oh, yeah, I put the dishwasher
I like that.
Hi, Barb.
See
The
you later.
other big boss that we're moving the table.
Well, we found out that, oh, yeah,